Yeah, I just got done. I've been dealing with something I wish I'd kind of known about the class and stuff earlier on. I just got done settling an agreement. It was on what would you call it? A civil case. I sold some property there outside Leander, Texas, and sold half my property to my neighbors. And owner financed it for 2 years to him with no interest. And when balloon payment time came, not only did they stiff me for the money, but they turned around and filed a fraud lawsuit against me on this Texas Deceptive Trade Practices Act and went after me for a few $1,000,000 trying to say I defrauded them and tricked them into buying the property that it was attached to theirs and all that stuff. And end of the day, it cost me about 40 grand to get my property back.
Well, you ought to sue them for the attorney's fees, and the ones that committed fraud on the contract. They breached the contract.
Yeah, yeah. But as part of this Rule 11 settlement agreement I had to do that my attorney handed over to me after I hired him and gave him a 10 grand retainer. And then a few weeks later, it's like, well, I don't have time to do this, and I don't have time to do that and everything. And then next thing you know, he comes back with a settlement with me paying them almost $30,000 back, which is basically $25K they'd paid in monthly payments towards the property. And that was it. But it just made everything look like this Deceptive Trade Practices Act thing was an almost unfightable act. And I didn't understand I'm starting to understand researching all the statute and reading statute related to this traffic offense and everything. And I probably at a later point will go back through it and see what if I could have beat it on my own rather than dealing with these filthy attorneys.
Well, attorneys love. That's why you don't give an attorney a retainer. You pay him for his work. You never give him a retainer. If they want a retainer, tell them to take a fucking hike. You'll find somebody else.
Understood. Loud and clear.
Because if you go look up the definition of retainer in every state law, a retainer to an attorney is a gift. He is not required to do 1 ounce of work to get it.
Really?
Really.
I did not know that. Wow. Well, I learned the hard way. It hurt, but we'll get back on the horse. I will after I get the deed back, my name and all that. I definitely intend on filing a bar complaint against him because the guy was like calling me and screaming and yelling at me and saying that he didn't say things that he said that he was going to do, this and that. Fortunately, I got...
Okay, I'm going to give you another bug to put in your ear that you better remember as well.
Okay.
There is such a thing as attorney-client privilege.
Right.
There is also the fact that you can waive it. So, in the off chance that you ever wish to do that, record your conversations with your own attorney.
I've got all of them.
Forever. Yep. Never talk to an attorney without recording it. Ever. And never tell them you're doing it unless the state requires two-party consent.
Yeah, it's Texas, and I recorded every conversation. I've got them down.
Well, then you may have him on a malpractice suit.
That would be awesome. At least get my 7 or 8 grand back from him. Thank you for that, Eddie. I appreciate it.
Yeah, in Texas, it's either Chapter 81 or 82 says very clearly a retainer is a gift.
Okay.
Chapter 81 or 82 of the Texas Government Code.
I will look that up. What I've been doing a lot is using the data that you've got for Texas and then doing cross-reference to try to find similar code in the Arkansas statutes. And man, Texas is pretty bad too, but just the language, are they really that stupid and that poor in their grammar, or is it just done intentionally to make it so that you can't follow, or it's really difficult to follow what they're saying?
Actually, the statutes are, for the most part, are fairly well written. When the problem is when you get into areas where they've put in multiple potential changes that all take effect at different times, but they all affect the same provisions. That's where you run into a big problem. But for the most part, they're fairly easy to read and follow. Once you understand how a statute is constructed, it becomes a lot easier. If you want to understand how to properly read a statute, there's 3 things you need to read. Chapters 311 and 312 of the Government Code, and the State Legislative Drafting Manual. You need to read those 3 things if you want to truly understand how to read and understand a statute.
State drafting manual?
The Legislative Drafting Manual.
Okay. Got it. Government Code 311 and 312, that's the Texas Government Code, right?
Yes.
Okay. I will look those up. I won't say I've got it down, but I'm definitely getting better with it with each past day. And then just tracking all the stuff down. Kind of with my deal right now, with this traffic ticket that I'm dealing with, I've found that in the state code, anything under 15 miles an hour is not, there's nothing relating to it as being a finable or punishable offense under 15 miles an hour. And so if it is an offense
under 15 miles an hour or 15 miles, no more than 15 miles over the speed limit.
No more than 15 miles an hour over, no more than 14 miles an hour over the speed limit.
Okay. Well, again, you read the articles I gave you on Arkansas statutes, right?
I did. I've read all that thoroughly.
Arkansas statutes very clearly say that it's regulating transportation.
Yep.
Okay?
Yep.
You're not engaged in transportation.
Correct. And I even did say that. I don't know if you listened to the recording, but I did say that to the officer. At the end of the deal, or towards the end of it, I was like, just to ask you, are you something along the lines of, I'm not involved in transportation here today. Does that make any difference to what you're doing here? And he kind of looked at me like he had no idea what I was talking about.
And he probably doesn't, but that's not an excuse.
No, it's not. It's not. Not an excuse. So I took one of your documents. Let me see what you called it. I've changed the name on this one to fit mine because it wasn't like this code here. Law. Oh, that George Gordon. I think I heard you mention something about him, or somebody else brought it up as far as the George Gordon common law classes and stuff. Did you say something about him, or was it a different Gordon that you talked about?
No, I know who George Gordon is. I don't talk about him a whole lot, but I have talked about him.
So I found some of his stuff online, listened to some of it, and then I contacted his school there because it's an hour and a half away from
he passed away, and there's no one that teaches at his school, but they have made everything on his website downloadable, so you can get everything he's ever put up out there for free. You had to pay for it. I guess they've changed that because they're selling his stuff now, and they follow his way of just only taking American Gold Eagles for payment. But basically, for what he was charging $1,500 for the court procedure course, they now want 1 1/4 Gold Eagles, which is around $5,000 for that one class now. And it's CDs or a DVD with 35 1 1/4 hour courses, and then a big stack of paperwork to go with it. But it's up to, from the 15 he was charging. I guess one of his students married his deceased wife or his widow, and the two of them are still running it that way through online and just sending out packages to people. So that was a little steep for my blood. $5,000 for it and not really have. Well, how much did you pay the lawyer that screwed you over?
Well, exactly. And if I'd have had that money in return to do that, I think I would have done it. I mean, at least it sounds like in the free recordings and stuff that I've listened to, it doesn't sound like, mostly it doesn't sound like a bunch of sob-sit bullshit.
No, it's not. He actually studied law. He's even set case precedent. There's actually case law that he's responsible for, stare decisis.
Yeah.
He's actually gotten several laws overturned as being unconstitutional.
Wow.
All right. Just so everybody has them, just so you can see the history, there is the 2025 Legislative Drafting Manual, as well as the 2008 and the 2014. So if you want to compare them to see that the things that are in them that are the same haven't changed, or at least they haven't changed much. One of the most interesting things you're going to find in the Legislative Drafting Manual is how they explain how the term person works in Texas law.
Okay.
And Chapter 311 actually mirrors that. I think it's 311.005, subitem something or other. I think it's 13. But the definition of person there mirrors the way that it's set up in the Legislative Drafting Manual. And that is the default definition statewide in every statute unless there's a local provision that changes the definition. See, that's why it's important that you read Chapter 311. Chapter 311 contains the definitions that apply across the board in Texas law. It applies to every code, in all of Texas. All right, who are we still missing? We're still missing Jane. We're missing Kevin. We're missing... Who else are we missing? Julie?
I'm here.
Oh, you're here?
Yes.
Okay, well, you're just not showing up on the list anywhere. Now you are. Okay. Helen, how far have you gotten on your case?
Oh, still turning stuff in it and working on it. So, and I'm still reviewing each part of each one of my motions that I had to refile, so that way I can make my my pleadings. You know, the one page showing each element that I need to argue that's within the pleading, and then the next page being
well, no, wait a minute.
Or how do I put it? So in a nice way, it's one side is each action that we argued. And so, for example, the one with the headlamp and the one with the failure to ID. So each thing that we argued, we put it on one page.
The thing about it is, that's a merits argument. That's for trial. That's not for a motion to dismiss. Okay? Dismissal is all about their lack of evidence to prove it, the lack of an actual offense, the fact the complaint's invalid because it lists elements that there is no offense for in anywhere in Texas law. And those are what you're arguing about there.
Yeah,
you're not arguing about the headlamp.
Right,
You're not arguing about the failure to ID.
But those are the motions that I filed from the lower court. Remember, I have to refile.
I understand that. Okay. But remember, you're arguing two different things here. One is merits, which you would have to argue at trial.
Right.
And the other is the reason why there should never be a trial.
Right.
Okay? Two very different things.
Yeah, well...
Now, if he's telling you that your motion hearing immediately precedes your trial, then you've got your notes ready for what you're going to have to get them to testify to and talk about when you're asking your questions at trial. But as far as stopping it from getting there, that's a different animal. Because anything you start arguing about merits, they're going to say, well, that's a factual matter relating to the charges. That's got to be argued at trial.
So Eddie, for those of us that are kind of new here to this and whatnot, can you give us a quick rundown of what those differences are and what she should be, or what we are looking to argue for a motion to dismiss? Because that's the first thing, I guess.
Okay. Well, let me give you an example. All right, or let me give you a question, and you can pick the example that would best suit you.
Okay.
If someone is accusing you of something and they say these set of facts are why you did it wrong, okay? But the thing you're saying that you did wrong isn't actually a thing. Do you want to argue about the points they're making, or do you want to argue about the point there is nothing wrong with what I did because it's not a thing?
Got it. Makes sense.
Okay? That's the difference.
That it even relates to you in the first place.
Correct.
You're not the person that it refers to.
Right. Yeah. I don't have to argue your points, because your points are irrelevant to the fact that what you're arguing about is not an issue to begin with.
Okay.
Think of it like somebody in Louisiana trying to charge you for under Louisiana law for speeding in Texas.
Yep.
Okay? We don't have to worry about what they're charging as far as speeding in Louisiana, because our argument is you don't have any jurisdiction to charge me with jack shit when I'm in Texas.
Yeah, and I already had that pre-trial, and they declared, oh, well, she needs to go to trial. She's arguing merits. No. But whatever.
Okay, well, that's the difference. You have to learn to recognize what's facts relating to the charges and what is something that makes the charges irrelevant. Okay, think of it like diplomatic immunity without the sovereign citizen bullshit.
Right.
Okay?
I mean, and we already know that, and we've already reviewed in my case, that there's no such offense codified as a defective equipment headlamp.
Right.
Nothing.
And there's no element of that charge that in the statute that says 2 headlamps.
Exactly. But okay? I can't argue that.
But you have yes, you can. You can argue that there is an element asserted in the complaint that does not exist in law anywhere.
Okay.
Okay? That's challenging the validity of the complaint, not the merits of the charge.
Right. So
the state is asserting an element of 2 lighted headlamps. There is nothing in the law that says that. Nothing.
So then the same would be for the failure to ID as well.
Well, the failure to ID is attached to the other. The failure to ID can only be an offense if you were lawfully arrested for some other offense first.
Right.
If the arresting you for the headlamp was unlawful, then the failure to ID charge is unlawful right behind it.
Yeah, well, the pullover was unlawful, period, because of that.
That's the arrest. Okay? Remember, every traffic stop in Texas is a custodial arrest.
And anything else they found during that arrest would be irrelevant because the traffic stop was irrelevant.
So, well, see, that's the thing. That's another question you can ask the officer. Officer, did you attempt at any time, once you pulled me over, to read me my rights or to inform me of my rights?
And the answer is going to be N-O.
No, I did not. I'm not required to do that on a traffic stop. Objection, non-responsive, and a legal conclusion. I asked the court to take judicial notice of the 2008 case of Aziz v. State, where the Texas Court of Criminal Appeals specifically stated that a traffic stop in Texas is a Fourth Amendment seizure for the purpose of being in custody.
Isn't that also under Miranda as well versus State?
Miranda's where they have to inform you before they question you and demand information from you. Okay? They tie together, but Miranda's not the linchpin.
No.
Miranda's a secondary thing to that.
So wouldn't Miranda be more affiliated with the production of
No, stop. The reason they have to read you your rights is because of Miranda. And the reason they have to read you Miranda is because of the case that says it's a custodial arrest.
Ah. So how could I put that as also an argument, because they never did either of those things, like reading me my rights or anything of that nature. So how do you argue that?
Well, there's two ways you argue it. The case of Aziz v. State and 38.22 of the Code of Criminal Procedure. 38.22 says that anytime an officer detains or arrests an individual, they have to read them the statement in 38.22, which is your Miranda rights.
Right. And they never did.
And they never do. They never do.
No, he just coerced me and said, "Oh, if you don't produce, you're going to jail. I'll break down your window."
Right. Without giving you any of your Miranda rights.
Miranda rights. Exactly. So, yeah. And that's all in the video, of course, that they produced. But they haven't produced me a video, which is my other argument. But, of course, they still rely on their 39.14D of the Texas Code of Criminal Procedure.
Which they're misreading and misinterpreting.
Which they're misinterpreting and misapplying. Exactly. Yeah, and that deals with both Brady law.
Have you filed your motion for discovery yet?
I'm working on the last part, yes.
Okay. Well, part of what you need to put in there is for the officer's personnel file, any complaints against the officer, any Brady information relating to the officer.
Oh, okay.
Is this officer a known liar?
Okay. Yeah, because I've already got the motion as to how the prosecution failed by denying me the production of the body cam and video footage. So.
Well, as long as you wrote up the argument the way that we stated it about why they're misrepresenting that section of the Code of Criminal Procedure.
Well, the part I'm on now is using the Brady law to make that argument more clear. So that way I can place sanctions against request that the court place sanctions as appropriate against the prosecution for failure to do
as
so.
I say, the argument there is multifaceted. The way they're reading and interpreting the statute is a violation of Brady versus Arizona. Period. No ifs, no ands, no buts. It's a violation of the right of due process for the individual to have access to any information that is to be used against them in a court of law. Okay? And if it is information, sensitive information like child pornography or things like that, that they cannot have duplicate copies of, they at least have the right to come in and look at it. But the information you wanted is none of those things.
Right. And I had the right to look at it, but I would like to have that copy as well.
Well, you have a right to a copy of it as well.
That's right.
And they damn well know it.
Yeah, they do know it. But they, and I watched the judge when he, like I said, and I told everyone in the last couple of classes, what I observed was the judge was going off of the 39.14D that the prosecution had brought up to one of the pro se defendants that did not file any motions during the time of his announcement docket. And he brought up the point that, well, the prosecution refused to release that. Well, 39.14D says that we're not required to, but that's still misapplication. But had he had done what I'm doing, is following the motion appropriately, he would be able to compel the court to do so.
Well, again, the argument there is that interpretation, if it's allowed to stand, is a violation of Brady. Period.
And Michael Morton Act.
Well, they're using the Michael Morton Act. That's what that's in.
Right.
They're intentionally misrepresenting D to circumvent A, and at the same time violate Brady.
Yeah.
Like I said, it's a multifaceted argument. It's not just one thing, it's multiple things.
And so, yeah, that's my other part that I'll be arguing as well. Plus that constitutional challenge.
She brings up a constitutional challenge on that. Been listening to some Carl Miller. Would you say that his stuff is generally good? I figure you're probably
I don't know who that is.
not familiar. He did a lot of constitutional. He was kind of in a similar world, although he didn't have a law school, but helped a lot of people out with constitutional law. So, but if you don't know it,
well, if he ever says anything about the Queen of England, the Pope, or the Postmaster General, you better run for the fucking hills as far away from him as you can.
Yeah, none of that. It's all strictly Constitution, all directly and strictly from the Constitution.
And here's another one too.
Well, again, Carl Miller was all from the Constitution too. That doesn't mean he was reading it right.
Anybody?
Carl Miller. That's who I'm speaking of. Is Carl Miller.
Oh, okay. The old guy with the baseball cap.
Yep, that's the one.
Yeah, he wasn't entirely correct in everything he talked about.
Okay,
He's not completely wrong, and he's not going off the deep end, but he is misunderstanding some things based upon history.
Okay.
And historical context. It's all well and good to read the words that are in the Constitution, but just like Scalia said, if you don't know what they meant at the time it was written, you're not going to read it right.
Right.
So you've got to go back and look at the historical meaning of that word and the context in which it was generally used, especially at the time of the constitutional debates.
I'll run off the deep end on that with the Patriot nut crap. Y'all watch out for the A for V crap out there, where they pay off your debts using your birth certificate. Watch out for that too.
Well, when I sent out the invitation to the class, some girl sent me back something I didn't ask for, but I did send her back something going, well, what I'd really enjoy is for you to prove that with verifiable evidence and facts.
Yeah, because David Young, the old man that moves from Florida to Philippines and constantly in motion, is the one that created that. And all the crap that you read in it, because my brother and my cousin have sent me that, and I'm like, oh, that's garbage.
Yeah, she says, hello, Eddie. Please, are you aware that it is a legal proven fact that it is illegal to use a legal name via copyright birth certificates registered to the Crown?
Or the all caps.
The Crown Corporation. Read the BCC RSS at Kate of Gaia WordPress for this simple, profound truth. Have a nice day. And I just wrote back, no, I didn't, but I would love to see you prove your assertion to be true using actual verifiable facts and evidence. Thank you.
Well, David Young, that old man, also, I think he says, I'll pay you $50,000 to prove it's wrong or something like that.
I think he ought to keep his money and actually prove it right. Because if memory serves, he's one of them that doesn't do that.
Because I think there's been people that have gotten prosecuted because of some of his work.
Yes. Oh, I'm quite sure. That's why his ass is in the Philippines.
Between Florida and the Philippines.
So you talk about historical context as far as the Constitution. Would reading through the Federalist Papers, would that be a good way to achieve that and get the historical data behind it?
No. The best way to do it is to find the oldest iterations of the dictionaries like Webster's and things like that that you can find.
Mm-hmm.
Okay. 1839 is as far back as... let's see. I think Bouvier's Law Dictionary goes.
Right, Bouvier's. So they would have been pre-Bouvier.
Well, not necessarily. They weren't doing a lot of word modifications in that time. They understood words have meaning, and they weren't going around changing them just for the hell of it.
So they didn't have legal definitions that were different than the standard.
No.
Okay.
If they never put a definition into the law unless there was a reason for it, because the rule being the common and ordinary meaning, right?
Yep.
So if the common and ordinary meaning was understood by everyone, there's no reason to put it in the law. The only reason you put it in the law is if you're intentionally trying to change it from the common and ordinary meaning into a legal meaning. That's the only reason a legal dictionary exists. So that you can take a term that people think they understand and make it mean something else when you're specifically applying it to law. That is rule number one about a legal dictionary. If the term exists in a legal dictionary, it is 1,000% guarantee it is being used in a way other than the common and ordinary meaning. No ifs, no ands, no buts.
Got it. I uploaded a copy to the chat of my current motion or discovery document to send to the police officer's supervisor, which I got here in Arkansas. I don't know if we end up with some time tonight to scroll through that. There's some things in there. Before I do my discovery for the county clerk's office and for the DA as well, I just wanted to know if I'm off on a tangent with some of the stuff I'm asking, or if it looks like it's all in line.
Well, like I say, I just got internet back a little while ago, so I'll have to look and see what's in your email before I can answer that.
Okay.
Hey, Eddie, I got questions for you. So, Jane has texted me today. She's not going to attend class, but she indicated and sent me copies of a habeas corpus that she filed. And she went to a pretrial hearing for. Did you happen to get copies of that by chance?
Again, whatever's in my email, I have not had a chance to go through. I got my internet back today about 3 hours before class started.
How long was it out for?
Since our last class, the day after.
Damn.
That's why I told you guys I needed y'all to get on and get your December subscription in, because I was running low on the ability to pay the bill, and nobody did. So that was that.
I paid mine on, I think, the 1st. So
Yeah, but that was not barely a little less than 2 weeks ago, which is my point.
Right.
So are you needing your payments at an earlier date based on the time you have to pay your bill, per se?
I have to pay the bill by the 17th of every month. And it was due the 17th of last month. And they extended it up until the end of the month, but then there was nothing to pay it with, so it didn't matter.
Fair enough. I guess you full-time and employed outside of this? You working doing data?
I do dog training and stuff like that out of my house, boarding, whatever I can get to earn money.
Okay, got it. I had sent you an email prior to the previous class that we had and everything, just checking to see if you offered any private counseling at a price, and asked you what your price was, and I never got an answer back to that email. So I just figured you were too busy working at a regular job or something like that that you hadn't got a chance to look at it, or just weren't interested in it. So
again, I haven't seen any emails from anybody.
right. Well, I'm saying this was prior to the last time that we had this meeting, prior to Thanksgiving. Prior to that meeting, I had sent you an email.
Yeah, and which email address did you send it to?
I sent it to the same one that you send us the links from to join the classes.
Okay, then I don't recall ever seeing that one. As far as I know, I've only seen 2 emails from you, and one of them was your subscription, and the other one was the one that you sent in the last few days.
Okay, well, I'll fire it to you again, and if that's something that you're open to or is an option, you just tell me what your price is, and I could use some to just kind of get me sped up on what I'm doing here. I'm behind the ball. I was able to file for an extension for my case here. I just told them I was going to be out of the state of Arkansas, not Arkansas State, but told them I wouldn't be available until sometime in March, which I saw their next trial in March, or trial day. They only do it one day a month here, and they put it all together. And so that'll be March 17th. I bought time to get all this together.
Okay.
I don't expect the class to be taken up doing all my stuff. So if you do have time,
Well,
and
we take them as we can get them. All
right.
right. The oldest dictionary you can get your hands on is that isn't going to cost you more than $1,000.
Right.
Is a 1755 Samuel Johnson's Dictionary of the English Language, reprinted in 1859. That's $465 on Etsy. Then you've got the only one that predates Bouvier's that I can see is the 1828 American Dictionary of the English Language, which is a Noah Webster dictionary, and it's from 1828. The first English dictionary of slang doesn't help us because we're not after slang words.
Right.
So that 1699 is the slang, so that one doesn't help us. So the 1828 is the earliest one you can still get that would have been anywhere near the colonial meaning of the terms.
But you say the 1755 Samuel Johnson one. I know it's got a price, but a lot of times you can find that stuff archived elsewhere. So I might be able to find a PDF of that. I'll search for it.
Well,
that was at the time of writing of the Constitution, whereas the other one was well after it.
all right. Who else got questions? Nobody? Well, that's unusual.
Well, I do, but I'm trying to let other people get there about their stuff before I start.
Scott, what about your case?
You say me?
Yes. What about your case?
Oh, well, I sent off the information request to Garland and gonna get them tied to the old tar baby, and then the criminal complaint sent to the DA and to that judge are just sitting there percolating. So in a couple weeks, they'll throw those in the trash. I'm sure they already threw them in the trash by now. And so I'll get to file criminal complaints on the Dallas County DA and some judge, magistrate judge, and just start tying them up. Send those complaints to another judge. And I was just thinking I might send one over to Garland and one over to Mesquite, since that's where it's all going to start at.
What's Scott got going on? What's his case about?
Oh, it's traffic tickets.
Same old, same old.
Yeah, I've been down this road for a long time. So, main thing is they're supposed to notify you of a court date. They never do. They never follow their own procedure, their own policy. So we're going to just start hemming them up, not following policy, and file criminal charges on all of them. It kind of turns into the saying, how many crimes can they charge? How many crimes can the government charge you or let's see, how many crimes can the government commit in order to charge you with a crime? So we're just going to start laying out all kinds of criminal complaints on all these public officials and eventually file suit on the judges and stuff. And these guys, they had nothing to do with that cop writing a ticket for my tags being out, or the second one is tags and running the stop sign and my license. So it's going to get quite interesting for them.
Because I'm kind of unfamiliar, Eddie, with a lot of your background and everything. What kind of successes have you had as far as holding these people responsible and winning lawsuits against them for these criminal acts that they've been performing?
I haven't ever filed a lawsuit against them. I've won lots of court cases of my own and helped a lot of other people win theirs, at least those that tell me anything about their case anyway.
Right.
And then I've, like for instance, we had Marnie's case in Austin when we went down there and caught the prosecutor and one of the judges on her case tampering with the record. Caught them red-handed doing it. And called them out on it and got her case dismissed. And just a whole bunch of stuff like that. 9 times out of 10, we've beat them on straight up procedural crap that they've done wrong. Criminal crap that they've done wrong. But lots of other times we've beat them on straight up on the merits. Speeding tickets, you name it.
Mm-hmm.
But I have yet to actually file a lawsuit against any one of them. Mainly because it's not my suit to file.
Okay, so it's been on other people's that it would have been.
Yeah.
And really related.
Like for instance, Marty had a lawsuit. Marty had a dead bang lawsuit against that city attorney and the judge in that case. But Marnie's got health issues and didn't want to go through the stress of trying to sue him and fight it.
Yeah.
So, just it's always stuff like that. Or the person tries to go it on their own because they won the case. They think they're a lawyer, and so they go to court and try to win it themselves and screw it up. So,
got it.
It varies. This is not something to take lightly or to attempt to do when you don't really know what the fuck you're doing. And that's true no matter who you are.
So are you suggesting that you just need to be better educated before you take something like that, or is that one of the cases where you would suggest actually getting an attorney involved in it, which I've heard you speak of before, other than if somebody's facing
Let me put it this way. If I have to tell you the same thing 10 times on how something works before you understand it, you should not be going to court without a lawyer.
Yeah.
Now, if you can follow along and make a coherent argument and stick with me when I'm trying to explain something to you or show you how it works in court, and you've got the right answers on how to respond to it and deal with it, be my guest. But the place where most people fail is they don't go to court and watch how shit works. And yet they think they understand it. They don't. You need to go to court to see exactly what they do and how they do it in all kinds of cases. And then you need to know in depth the rules they're supposed to be operating by so that you can identify where they're not following the rules when they're doing what they're doing in court.
Yeah.
If you can't do those things, then you can't prevent them from screwing you over. If you can't prevent them from screwing you over, you just went there to lose. And that's where most people get it wrong. They think that, it's like that Ray. There's a case I wished I'd have never tried to teach him how to fight. We spent 8.5 months on Ray's case trying to teach him how to fight because he was illegally detained and arrested for sitting in a truck at a place he worked eating his breakfast.
Wow.
And while he and a friend were sitting in the truck waiting for their boss to show up and open the business, DPS pulled over a car right in front of them in the business parking lot. And when the DPS troopers noticed these two guys sitting in the truck eating their breakfast, they abandoned their traffic stop to harass the guys in the truck.
Oh, my goodness.
And then arrested them for failure to ID. When they had no obligation to ID.
What was the outcome of that?
Well, his lawsuit got dropped because Ray wouldn't listen. And when he went to court on the charges, I was with him. I told him what to say, what to do. I was sitting right behind him, telling him exactly what to say and do. And what does Ray do? He turns around, gives me a big ass grin and a thumbs up and says, I got this. and then proceeded to do every goddamn thing in the world I had just told him not to fucking ever do. You get it?
Wow. Sounds kind of similar to what it seems like Jane's been doing.
That's a way of putting it, yeah.
Yeah. It's got to be hard. I don't really understand why people, I'm taking your class because I consider you a subject matter expert on this, and I want to learn from you with what you've got for me to be able to win this case, because I don't know jack shit outside of it, and I know you've got a lot of experience at it. So I don't really get why people come in here to take your class, pay you, and then turn around and do the complete opposite of whatever it is. And that's not trying to, gouge anybody or anything like that, but it just doesn't make any sense. Why are you paying somebody it's supposed to be an expert, taking their advice and not following a damn bit of it? So,
that's people always thinking that can't think on their feet or want to think they know better.
Yeah.
Because they're the first thing they tell themselves is, well, he's probably never been in this situation, and so what he's telling me won't work here, so I'll do it this way.
No, they've also made an argument that you're doing it the hard way or the long way.
Well, here's the thing about the so-called long way that I can't seem to get too many people to understand. Have y'all seen the old episodes of Star Trek where they play that 4D chess game? It's 4 different boards stacked up at kind of angles over each other, and they can move the chess piece between any one of those 4 boards. Okay?
Yeah.
Court is very much like that. However, there's one rule about 4D chess that's the same as it is in regular 2D chess. And that is this. Have a fucking plan. And in that plan, the order in which you move your pieces and where you move them to has an effect on how well your plan progresses and whether or not you win the game. Now, who in here would argue that it doesn't matter which chess piece you move when and think they can win a game that way? Would anybody make that argument?
Not at all.
Well, that's the argument Jane was trying to make. Okay? Well, I went back and fixed it later. Well, too goddamn bad. You've already lost the fucking game because you moved that piece the wrong direction way too early. And you didn't give it any protection. You didn't use it to set up a next move. You just threw it out there and sacrificed it to the fucking wind. And that, ladies and gentlemen, is exactly what you'll be doing if you don't go in there with a fucking plan. You move every piece you have to move. You move it with deliberation and purpose. Period. You have a reason why you move it, and you expect something to occur because you moved it. You want to get some reaction out of the other side, and you hope that the way you moved it caught them in a way that will get the result you're anticipating and force them into it. That's chess. That's always been chess. That's court. You either want to move your piece to give someone a focus and create a blind spot, or you want to move your piece to force them into having to contend with it and take it on from one or more different ways that leave you with an opening for your next move. That's always the plan. And the more of those moves you can think ahead, the more likely you are to be the one that wins. Unless the other person can think more moves ahead than you do.
Well, generally, they just cheat.
When there's losing, they'll cheat.
Yeah.
Okay? And sometimes they'll cheat by trying to alter the board before the game even starts. Like what they did in Marnie's case when they tampered with the record. They tried to change the whole fucking board before the game even got started.
Go in there and they added something or deleted something from the file?
No, they dismissed the original case and refiled it under a new case number, which eliminated everything she had filed in the original case. And they did it the day before she was actually supposed to appear in court for trial. We had them dead to rights. They were going to lose, and they fucking knew it. So they dismissed the case in secret, refiled it in secret, and then tried to act like nothing had changed.
Huh.
And we caught them at it the night before she was supposed to appear in court. And the reason we caught them, because she followed fucking instructions.
She went down and checked the court record.
That's right.
Got it. Okay.
Okay?
Yep.
What is my rule on checking the court file? Not asking someone to get you a copy of it, going and checking the actual court file. What is the rule, ladies and gentlemen?
Up until
I thought it was check it every week and then every the day before and all that.
On the week of the
You
trial,
check it at least once a week if you're close enough to do that, but never less than twice a week if you've got a long period before you go to court. But once you get a court date, the closer you get to that date, the more frequently you check it. The week of court, you depending upon what day it is, you will check it the Monday, Wednesday, and Friday before the day of your court, period. So if your court is on a Monday, then the week before you're checking it Monday, Wednesday, Friday. If your court is on Friday, you will check it Friday, Monday, Wednesday, Thursday before you go to court on Friday.
And this is going in physically in person to look at
Yes, because you cannot trust somebody to give you everything that's in that fucking file.
Yeah. And that would be achieved by going to the clerk and asking for the court record.
Yes, I need to see this court file, please.
Okay. Fortunately for me, I pass court on my way home from work every day. So
and that's what I mean. If you're in the vicinity where you can do that, then you have the ability to check it more often. Do it. But failing to check that court file will screw you more than anything you can imagine. Because if you've got them over a barrel and they fucking know it, that's the kind of shit they'll pull. But by dismissing her case, which was under, let's just say, cause number 1, 2, 3, 4, 5, 6, 9A, and refiling it under 9, 8, 7, 6, 5, 4, 3, 2, 1C, everything that was filed in the first case stays attached to the first case. It doesn't carry over to the new case. And so all of the motions we filed, all the pleadings we filed, all the complaints we'd filed was all washed away by the dismissal of the case and then filing a new one.
And there's not a time requirement on that for the new one?
Of course there's a time requirement on it. And there's a notice requirement on it. And they didn't comply with either. And that's what we caught them doing. And that's why they were dead in the water the moment we caught them.
So did they dismiss at that point then?
We showed up in court and they immediately, what they did was, I told her to get copies of everything from the original case, change the date, refile them, and get them court stamped right then and there while she was in the lobby of the court. So she got the clerk to print out copies of everything we had filed in the original case, and she refiled it in the new case. So while she was doing that, I was writing a new motion to dismiss, letting them know how we'd caught them red-handed, what we were going to do to them because we'd caught them red-handed, and we were going to get their ass fucking disbarred. And then I emailed that to her, told her to get the clerk to print it out, file a copy of that, and make damn sure you keep a copy. Next day in court, they call her name and say, here's your dismissal. And they gave her a dismissal and sent her out the door. Because now we'd caught them, we told them we'd caught them, and they were screwed. There's no way in hell they were going to try to get her to go to trial with that.
And in that case, would she been able to go ahead in the aftermath and file for malicious prosecution?
Oh, absolutely. She could have sued for malicious prosecution and criminal charges for tampering with a record and rights violations under official oppression and abuse of official capacity. Those are both Class A misdemeanors.
Just wasn't interested or driven to go after.
Like I said, Marnie had health issues and was already under so much stress from the case she had. There's no way she could have survived a lawsuit.
Got it. Understandable. It's pretty damn stressful. I'd say from the one I was telling you about, just with my land issue and all that, I was more stressed than I think I could recall being for many, many years.
Well, I'm going about it a different way where I'm sending the information request for the case file and they denied giving me that information, saying that I had to show up down there and present an ID, which is bullshit. And so that's when I wrote up a criminal complaint against the clerk, a couple of them, and sent them one to the DA for the information side and two to a magistrate judge. And so now it's going to get that clerk all kind of wound up into it, or city secretary, whoever she was, that signed the bottom of it. Mm-hmm. And the next thing is I sent in an information request on Brady training. And so the city attorney had wrote to the AG to get an AG opinion, already submitted an information request about the cops' authority or, some other stuff that Eddie basically put it together. And anyhow, that's when the DA will get that one kind of figured out for him submitting an attorney general opinion on why he doesn't have to answer for the Brady, and this goes to Brady v. Maryland, 1963, on, handling exculpatory evidence favorable to the accused. And so when that guy will get that one figured out, will be filing criminal complaints against the city attorney. And then all the other attorneys that are in that same municipal office will get a criminal complaint against them for allowing this guy to do this. And then bar grieve them. And I still don't have a copy of the case file.
Well, in case y'all didn't bother to look at the Public Information Act handout that I made for everybody, there are now 3 criminal complaints in it. One of them goes to the county and district attorney, which is this one here, which is the one for the violation of the Public Information Act. Those must go to a county or district attorney. However, the Class B misdemeanor of official misconduct is charged under official oppression and abuse of official capacity statutes, which are Class B misdemeanors. Okay? And those 2 complaints go to a magistrate, any magistrate. So there are now 3 criminal complaints at the end of that document. So when y'all edit those and file them, make sure you understand who they get filed with. And I may go ahead and put a note on it about where it has to be filed, but
yeah, I thought it was at the top.
No, it says what you're charging. It doesn't say who to file it with.
Well, that in the whole document that you have.
Yeah, the document explains where to send it.
Yes.
Okay.
Right.
But again, I'm assuming people are reading shit.
Well, they kind of need to start out with it.
Well,
the information request this is going to be one of the things that's so easy to do. You can do it in your underwear because you're mailing it out to them, and they're going to screw this up every time. They're going to deny information, and that's what they do. They don't want you to know. They don't want to admit anything either. And so filing these criminal complaints, I filed a ton of criminal complaints back in 2017, and bar grievances and all kinds of stuff. Oh, man, they get to jumping up and down a little bit. Especially when you start bar grieving them. I don't even know who the judges are. I'd already filed judicial conducts for the judge that issued a warrant without ever notifying me of a hearing.
Yeah, which under the 2017 revision of the statutes they can't do.
Well, and that's why I'm going after them on their own policy.
That's not policy, that's state law. That's right in the Code of Criminal Procedure. They can't do it.
Yeah. But their policy is the one that they're applying to violate state law.
Well, you're assuming it's a policy instead of just a practice.
What's the difference between a policy and a practice?
Policy's written down.
Okay.
Okay? If it's not a written policy, then it's simply a practice that they engage in that is in a violation of law.
That brings up a good question then. It's like that needs to be an information request. Is like, what is your policy or practice for issuing a warrant for somebody that was never notified of a court hearing?
No. That's not the way to ask for it.
Okay.
The way to ask for it is please provide a copy of any written policies and or procedures or a statement of your ongoing practice on the issuance of warrants for alleged failure to appear on Class C fine-only misdemeanor citations.
That's juice.
That's how you ask for it.
Okay.
Because the way you're asking it gives them a heads up going, this guy's asking about something we did to him. The other is just a general question. It can't be directly affiliated with anybody for anything. Never, ever show your cards when you don't have to. The only time you show your cards is when you've been called. Period.
Well, that's going to be an information request they're going to send out this week.
Well, when you download a copy of tonight's video, you can go to this point in time, which will be right before the full hour's worth. And you can find it there and put it in.
Yeah.
Eddie, can I ask you a question about policy?
If you want to.
So, are you saying policies are legitimate if they abide by the actual underlying law, or can they make up their own shit?
Their policy cannot violate law.
Right.
Period. Doesn't matter who they are. They cannot create a policy that is itself a violation of law.
So
banks do it all the time. Courts do it all the time. But that's because no one knows what the law is to call them out on it.
Right.
Or no one knows what their actual policy is to call them out on a violation of the law.
Well, that's what I'm digging into in two different instances. I have a Wyoming court talking about their procedure / policy / procedure. And when you call them out on it, they say, well, we can't give legal advice. But when they made an error that holds them to the accountable, all of a sudden they're quoting law, which I said, thank you. And I looked up the law, and the law is vague on the topic. So they picked a version of their interpretation that benefited them. And this is what I get really sick of. Why, when somebody makes an error, why is it always, weighted towards them to benefit? We have to, unravel it for them.
Well, because they're not there to serve the public, they're there to serve themselves.
Well, hang on. An error is an admission of guilt. That's why people have errors and omissions insurance. I have E&O insurance. A mistake, if you say it's a mistake, then there's no liability. But an error creates liability.
Well, she even went to the county attorney to get an explanation because nobody had ever asked her the question to the point because she didn't fucking know. So she said she's going to have the county attorney call. He never does. So they know they don't know what they're talking about, but they're standing on some position, which ended up fucking my statute of limitations. So I'm not sure what to do about that yet, because if I start raising all kinds of hell, it's going to get back to the judges.
Well, again, they're not under any obligation to answer legal questions for you. That's your first problem. Okay? If they can find a way to spin it as giving legal advice, they're not required to answer it.
But are they required to misguide us into the judicial, not the judicial process, but just administrative
They cannot intentionally mislead you about the law. Okay? That they cannot do. But again, you'd have a hard time proving that their misleading you was intentional. Just like you'd have a hard time proving what they actually said to you if you didn't record it.
I record everything.
I understand, but what I'm saying is, since is it video or audio?
This was all done over the phone, yeah.
Okay, so it's all audio.
Yeah.
So there's no facial expressions, there's no seeing what was going on, what context they said it in, none of that stuff. All of that makes it much harder for you to prove succinctly what they did or didn't mean by what they said. You understand?
I do understand, but this was a little more specific. I simply asked, is the date stamped today for my submission for this case? Yes, I've stamped it today and it's down in front of the judge today. Great.
Okay.
2 days later, or 3 days, actually it was almost a week later, I get no response because they won't let, in state court, we don't get electronic notice. We always have to call in. And so I call in, what's the status? Well, your motion for informa pauperis was denied. I'm like, okay, great. So you're forcing me to pay. Can I pay? And they said, oh, and by the way, your date has been changed.
Wait. When did they have a hearing on your informa pauperis?
The judge did it within a day or two.
Like I said, does state law require a hearing when you file an informa pauperis?
No, this is just a motion before the judge, so I don't think it's a hearing.
Again, motions get hearings.
Good point.
You have the right to be heard. So what does the statute say regarding the filing of informa pauperis motions?
Well, they don't call it informa pauperis up there. That's the thing, is I couldn't find specifics, which brought me to this vagueness. And I won't get into weeds here, but just to be clear, Wyoming has a lot of vague holes in their law, meaning they haven't addressed very specific things, and they're always catching up because somebody will point it out or some error will come up. And because there is this vagueness, there's basically a void in the interpretation of it. They went to some other law that has to do with fees and starting processes, and they use that. But in there, it says nothing about indigency, or they don't use the word informa pauperis up there.
Okay, what were you seeking indigency for?
Medical hardship.
No.
Inability to pay due to medical hardship.
Listen to me. Inability to pay the fine, inability to pay a filing fee. What were you saying you didn't have the ability to pay?
Filing fee.
Okay. Civil suit?
Yes.
Okay. Wyoming statute doesn't explicitly list a specific statute number for a defendant's indigency regarding civil filing fees. However, the process is handled by filing an affidavit of indigency and request for waiver of fees and costs as outlined by the Wyoming Judicial Branch. This form is used when a party cannot afford court fees and there is no fee to file the affidavit itself. Procedure. A person who cannot afford filing fees should file an affidavit of indigency and request for waiver of fees and costs with the court. Okay? Doesn't say it's a motion. It says it's an affidavit. Let's see. And Wyoming statute section 5-3-206 of 2024 deals with fees. And 14-2-318 of 2024 deals with costs of proceedings. So I'd try reading those two sets of statutes and see what you can find. just for
I
the
did.
sake of learning it.
I did. And they talk about that in order for something to commence, the fees have to be paid. That's obvious, but they say, but how the clerk is interpreting is before they will even submit your document, you have to pay for it. And that's not how it all writes. It has to do something with the Treasury. It's nuanced and vague and all that kind of stuff. And so because they've been doing it for years the way they're doing it, they decided to consult after all these years to get verified, clarification of their actual job with the county attorney, who advised them of what to do. And then he was supposed to call me and talk about, well, this is why I'm doing what I'm doing. Of course he doesn't. So it's vague enough where I can contest it. They're not super confident about it. Otherwise they would have said this or whatever. It's the first court I've ever run into this. Usually when they deny it, it's the first time it's ever been denied too. Usually when they deny it, they give you 7 days, 15 days, 30 days. There's always something. And they're claiming there is none because it isn't written anywhere. Therefore, you were required to pay. So they were giving me the procedure ahead of time because I was asking over and over again because it is vague. And then they said, well, several of the clerks said, yeah, here's your deadline, or here's, yes, we've stamped it, it's in, it's all good, and it's before the judge. But because the judge denied it, they removed the stamp.
Well, the thing is, there's nothing in here about a judge denying it. What's in here is an affidavit for it, and they even set aside $10 of the $40 filing fee to go to that service for indigent civil legal services.
Right.
Okay. But there's nothing in here saying, how to appeal a denial or on what grounds they do deny it.
And it's the first time I've ever had, of course, it's the first time I've had a denial, but it's the first time I've had a judge say one word, denied, without an explanation. So I'm in a different ball field, and that's the thing. The rules are vague, and they're kind of doing it off the whim. And that's why I asked the question about policy/procedure, because it's not supported anywhere in law what they're doing.
Well, again, there's the rules of procedure for whatever kind of court you're in, civil or criminal. Every state has them. Every state has to abide by them, provided you know enough to force them to abide by them. They'll cut corners where they can and get away with it when you don't know how to say no. Okay?
Well, I followed the rules. It's the deadlines that I was concerned about. And again, because the law, like you just stated, does not specifically say if you're denied, you also lose your statute of limitations.
No, but the law will say that they have a set time to respond to it, or give you notice of it, or approve or deny, grant or deny, whatever you're asking for. So again, it's not just one set of statutes you've got to read. You've got to understand the procedure as a whole. There's a beginning, there's a middle, there's an end. And then there's everything in between all of those points. It's not just one thing, ever. Okay? There are chapters and chapters and chapters of procedure.
Okay.
And not everything is always organized the way you think it ought to be. You may have one place that's talking about a motions hearing, but then you have a completely different place where actual motions are talked about. Do not assume they're together. Do not assume that's the only statute that applies. That would be a big mistake.
Understood. All right, then back to the original question. This is for the other court. Policies and procedure. You and I have talked quite a bit about the fact that they have these first appearances.
Policies and procedures. Those are two different things. Policy is something that they can use for their internal functions. Okay? How they administer the court, who's got what job, who has to take the collections to the bank, how they have to mark it, how they have to count it. Those are policies. Procedures are written into law. They are statute. They are very different from policies. They are less malleable. They are far less negotiable. They are far less optional. You get it? Do not conflate the two. Do not mix the two.
So how
Learn
do we
what thing you're looking at falls in what category.
I'm talking specifically out of first appearance, which is a procedure that they have taken out of context.
Taken out of context based on what presentable facts? What's the facts to support your argument it's out of context?
Well, Colorado law does not support any of the actions of a first appearance center. Basically, usurping, you're forced to meet with the DA once, judge second, first, sorry, DA
Texas
first.
law doesn't support that either. Neither does due process.
Right. So they have taken a policy and turned it into a procedure and tried to mix them. I'm trying to unmix them appropriately.
No,
and that's
what they've done is they've created a procedure by misinterpreting and misapplying procedure that already exists in law. There's a difference. They're going to tell you what they're doing is procedure, but it's not the procedure written in the law. That doesn't make it a policy. That makes it a misapplication of procedure. Again, a very different animal. Because that is actually illegal. Not following their policy isn't illegal. Not following proper procedure in a way that violates the law or the rights of an individual is most certainly criminal. You get the difference?
Yes. So what I'm trying to present, and again, I won't go on much more, is just to how, so I have a judge in the federal court who has no idea about the local county and state laws. He is a federal judge in Colorado, but he doesn't know the local rules, so to speak. But it doesn't matter. It's the Colorado state law that governs this procedure.
Okay, if Colorado state law is governing, why are you in a federal court?
Because it's ultimately a constitutional violation.
What is ultimately a constitutional violation?
Being forced into a non-judicial process, violation of rights, violation of Fifth Amendment.
Such as?
Trying to get a guilty plea without representation, forcing me in there under, it's
okay, stop. Again, if you choose not to hire counsel, that's not forcing you anywhere, because you have the right to act as your own counsel.
No, this is, again, the first appearance. I had applied for counsel. I'd actually applied for a public defender. They knew that. I was not legally required. I guess
But they're trying to say they don't provide counsel because these are not jailable offenses.
No. I was not required by any law to be at this meeting with the DA. This was pre-arraignment, just as they do in Texas, right? So, two things. I did not have to legally be at that meeting under any law. Yet they imply that if I didn't be there, there would be some consequence, air quotes. What's the consequence? A warrant? So they're implying if you don't show up, there's going to be a problem. Well, what's the problem? There is no problem. Even the public defender later on said, yeah, you didn't need to be there. Okay, then why are 40 of us in that room? Right? And two, I sit down with the DA thinking that, okay, let's have at least a civil discussion. There was no discussion. He tried to get me to plead guilty to something he had never vetted. I told him to go F himself, basically, in a polite way, and he runs out of the room. And now he summons me to the actual arraignment. Who gave him judicial authority to, first of all, force me to talk to him, and two, to summon the court to actually get me to the arraignment? So a number of civil rights, violations there.
So did you file a lawsuit? Is that what you did?
I did, but the screening judge, the magistrate, is trying to dismiss it under Imbler, and that's all he's using is Imbler. and he's trying to twist the words into, well, this was administrative and investigative, even for your case, so it doesn't matter. Well, where does that involve me? The DA can do whatever he wants on his own time. Why does it involve me? And that's what the judge is missing. And I'm trying to.
Well, the argument there is, Judge, when they bring me in to ask me for a plea, that's not investigative. That's prosecutorial. The taking of a plea is done in the process of a prosecution, not an investigation.
But before who? A judge? Yes.
The prosecutors have no legal authority to accept the plea or to or in any way petition for one.
Agreed.
Okay, but again, what does Colorado criminal procedure say about it?
Your first
there has
meeting,
to be a statute that says when and how a person has to enter a plea.
I have it. And it's specifically your first appearance, air quotes, is before a judge. It's an arraignment.
Again,
now,
depending upon, not every arraignment's an arraignment. Okay, that's the other problem. For instance, here in Texas, they call the first appearance an arraignment too, but it's not an arraignment. It doesn't even resemble an arraignment. And Texas law does not allow arraignments in Class C fine-only cases. Nothing in law says a damn thing about an arraignment in a Class C. Nothing. Yet they do it all the fucking time.
Yes, they do, because my first appearance said it was an arraignment appearance. I'm like, how the hell is it an arraignment? I'm not being jailed right now, so that's messed up.
Well, jail's irrelevant. The purpose of an arraignment under Texas law is to fix your identity and accept your plea. Okay? That's what it is when you're charged with a jailable offense. That's the procedure. But under Class C fine only, Chapter 45A contains no such section and no such provision as an arraignment. The plea is not even required to be entered until the jury has been impaneled in the case, which means you're at fucking trial.
That. You cannot get them to understand that, no matter which way I've put it. These dumbasses don't want to understand it.
And that's why we file charges against them and complaints against them the moment they do it, because they're not complying with the Code of Criminal Procedure. And it's, something they can't circumvent. They have to do what it says.
Here's another twist to think about it. If that attorney brought you into that hearing and there is no judge there, he's simulating a legal process.
Exactly.
Well, in Texas, there's a law for that. Is there a law for that in Colorado?
What's the law in Texas, Eddie? What does it say?
It's under Chapter 32, simulating legal process.
Yeah.
And it under Chapter 4, is it 45? 2A,
no, Chapter 32 of the Penal Code.
Chapter 32. But didn't we find a part under the Texas Code of Criminal Procedure as well where the prosecution couldn't be, it could only be the certain ones like the county attorney, district attorney?
Well, that's the Texas Constitution. The Texas Constitution says it can only be the county or district attorney.
Yeah.
But 45.201, which is now 45A.005, is still trying to authorize a city attorney to act as an attorney for the state, despite that section saying that this does not make a city attorney an attorney for the state. So it completely fucking contradicts itself.
Yeah, so that's another constitutional.
The city attorney shall prosecute, yet the city attorney is not, cannot, and shall not ever be an attorney for the state. Well, that's contradictory.
That's contradictory to the Constitution.
It's contradictory to itself, not to mention the Constitution.
Yeah, so it makes it null and void. So there's where you put in a constitutional challenge.
Right.
But
back to the
motion that I think is.
You're going way off in the background, Helen. Can't hear nothing.
I said you've also filed a motion where the city attorney can't prosecute.
We filed a motion challenging the city attorney's ability to prosecute. Doesn't mean they're going to do what we argue. So don't say it makes it where they can't prosecute. No. We're arguing they have no legal authority to prosecute no matter what the fucking statute says.
So it's just better to let them fuck up so that way we've got it on record that they
Yeah,
fucked
so
up.
we take it to appeal to challenge the statute.
So, as part of this simulating legal processes, I've heard you speak before about giving the police officer with the citation giving a notice to appear.
Yeah, when he was saying that he was issuing you a summons via the citation, the summons is a judicial process. He can't issue a summons.
So would that fall under simulating legal processes?
It would have at the time. That's why they amended the statute to make it where they can no longer issue a warrant for failure to appear on the citation.
That's Texas issue.
Yes. In Texas, they can no longer treat the citation as a summons.
Really?
Really.
When did that happen?
2017.
That's awesome. Colorado, we still have that.
Yeah, it's a violation of due process because that's the exercise of a judicial power by an executive functionary. That's a separation of powers violation.
So back to this void of a statute or lack of a statute, if they make up a process without a statute supporting it, i.e. a first appearance center that isn't supported by any statute.
No, that's the wrong way to look at it. That's always the wrong way to look at it. Not every single thing they do has to have a verbatim statute that authorizes it. The question you always ask is, does what they're doing violate any statute? Period. That's the only question, always. Is how they're doing this, does it in any way violate any statute or any requirement of due process, meaning any individual right to said due process? That's always the question. If the answer to that question is no, then there's nothing wrong with the way they're doing it, despite the lack of a statute saying they can do it.
Then why are we arguing about a first appearance center then? Because they could just make up whatever they want if there's no statute behind it.
Because I guarantee you there is a statute that says what a first appearance is and what they can and cannot do at one.
That's the one I read, but it doesn't go into specifically misdemeanors.
It doesn't go into what kind of misdemeanors.
I don't know the level that I'm in, but I'm in, it's a third degree.
Well,
so
can you go to jail for it?
If I don't, not initially, no.
Is it a fine-only offense? In other words, they cannot sentence you to jail as part of the punishment for the offense.
I think so, but I don't know specifically.
Well, then how can you be arguing what the offense is or isn't if you don't even know what the hell the law says it is?
It's because I haven't read it in almost 2 years.
Well, then you better start committing this shit to memory. If you think you can go to court and argue with notes, you're crazy. You've got to have this stuff internalized to the greatest degree possible. Everything I'm sitting here telling you guys right now is coming off the top of my head from memory. It's not coming from notes in front of me. You want to know where to find it? I can tell you where to find it. Or get you damn close. At least in the right chapter, if not the right section. But the point is, I've got it internalized. It's not just something I saw once and forgot about. Or I can say I forgot about it because I haven't read it in 2 years. I haven't read the transportation code in 7 or 8 years, and I can still tell you every section that deals with what.
Do you use a specific means like flashcards or something like that?
No, I just read and I write. The best thing for me to retain it is to write about it. I sit down and I write out my arguments about a statute. If there's a section in there that I find, okay, this contradicts this, contradicts this, contradicts this, then I sit down and write what I refer to as a legal white paper, arguing about how these things allegedly interact, but how that interaction either doesn't work as a matter of law or creates more obfuscation and problems than it solves. or vice versa. That the way they're reading it creates more problems than the way it's written. If they read it right, this is what it would work as. And this would actually function the way it's intended. The way they're doing it fucks it up. By the time I'm done writing all those things many times, many different ways, I'll never forget that shit as long as I'm breathing. I have written literally thousands and thousands of fucking motions for people. So I get to refine this every time I write one. Is there a shorter way to say the same thing? Is there a more an elegant way to say the same thing? Is there a more succinct way to say the same thing? Is there any part of this that doesn't make sense because I've got it in this order or that order? Okay? Refine it, refine it, refine it, distill it, cut it down, make it shorter, make it straighter, make it cleaner, make it more straightforward, less convoluted. Going through that practice over and over and over again. I'll never be able to forget this shit. If I wind up with dementia, this will still be the shit I won't forget.
Well, good. We can always talk to you. Then we can tell you what a great guy you are, and you'll forget that. Then we can ask you.
I never remember that anyway.
So if a petty offense has jailable time, how does it affect this process we talked about?
Well, they can't send you to jail without the right to counsel, period. That's set in case law. They absolutely cannot do that. So if they're denying you counsel, even at an arraignment, and the offense they're charging you with is jailable, that's a rights violation, straight up and down. That's a 10 out of 10 fuck you rating right there.
Okay. I brought up a Fifth Amendment with that. Well, one of them like that, without denial of counsel or forcing me
into... If I'm not mistaken, counsel's Sixth Amendment, not Fifth.
Fifth is self-incrimination.
Correct. Which is
okay.
Not the right to counsel.
Okay. I think I got the Sixth in it too. I don't have my complaint in front of me. But back to this thing, how can we be the sequence of events according to the Colorado statute? Again, it's for felony, mainly the statute, but it also vaguely talks about just criminal offenses, is that you go before a judge. That's your first move.
Okay.
However,
hold on. Here in Texas, there are two separate parts of the Code of Criminal Procedure. One deals with anything that's not a Class C fine-only offense, and one chapter deals strictly with Class C fine-only offenses. Excuse me. So the question is, does Colorado have something similar to that?
Well, this isn't a fine-only offense. I just looked it up again. It's a 10 days in jail max and $300 fine.
Okay. Then they cannot deny you in having your right to counsel, even at the arraignment.
So back to this first appearance, I'm forced to meet with a DA1, who then can summon me to meet with.
Now you file bar grievances against the district attorney and a judicial conduct complaint against the judge presiding over the court where he's pulling this shit. Okay, and don't just send it to the State Bar Association and the State Judicial Conduct Complaint. Take both of those then and send them to the United States Attorney's Office for that area, and then send a copy to the FBI.
Okay.
You want to stir the fucking pot? Get a big fucking spoon.
Well, I also want to add the county in the lawsuit for allowing this.
Well, again, the county, first off, you'd have to show the county has supervisory authority over the judges in the court. You're not going to get that.
What about the DA?
Again, if the DA is acting outside of his lawful authority as a prosecuting attorney and he's subverting rights while he's doing it, then there's a very good chance you can sue him because he won't have immunity for that.
That's what I'm trying to argue.
He was acting outside of his purview as a prosecuting attorney by deliberately violating the due process rights of those people he was summoning into those meetings.
Right, and he's going to blame the judge, and the judge is going to blame the court.
I don't give a shit if they blame each other or not. If we can get them pointing fingers at each other, then we got them both on the hook, and they fucking know it.
That's what I'm trying to do, exactly. But I've got a federal judge who doesn't know this scheme. He was a prosecutor himself way back in the day, and he just thinks, well, DA equals immunity. And that's pretty much what he's saying. DA.
Well, there's plenty of case law that says DA not following the law and violating rights as when he's not acting in the capacity of a DA, there ain't no immunity. So the argument here is very simple. He was not acting in his capacity as a DA. He was simply using his position as the DA to cover up his unlawful acts where he was acting extrajudicially. Okay? He was doing it under color of law, not actual law, and thus not actual jurisdiction and not actual immunity.
Okay, I like that.
It's the same thing as if he was impersonating a DA at that point.
Well, he was actually impersonating a judge, was he not?
Again, that depends on what he actually asked you to do and what he told you he was capable of doing. But at a very minimum, you've got impersonating a district attorney, a whatever kind of officer they are in Colorado.
Okay. All right, I'll hash that all out. I'll look up all the laws tomorrow, actually.
Hey, what about, discrediting the attorney or city attorney, discredited them, or even discrediting the cop? What do you think about the cop using their emergency lights to pull you over to initiate a stop? Well, if you look under the code for emergency lights, it doesn't give them authority to stop you, does it?
Yes, it does. The transportation code does.
So, okay, so there's no way to kind of go after them for using lights or anything to...
Sure there is, if you can prove they didn't have an offense to pull you over for to begin with.
Well, that's the thing,
The thing here is you have to remember what I said earlier. A traffic stop in Texas is a Fourth Amendment seizure.
That's true.
Most importantly, it's an in-custody Fourth Amendment seizure.
Right.
Which means there are other things that kick in. 38.22, i.e. Miranda.
Uh-huh.
Which they never fucking do.
I got that.
While demanding that you produce information and answer questions. Which is a custodial interrogation.
Right.
Which you don't have the assistance of counsel or your Miranda rights warning to say, I wish to invoke my right to remain silent. And then they try to say that if you invoke your right to remain silent, then you're wrong for doing it because you're answering questions that you're required to answer by law. Well, the problem is, all these other things are by law too. Which one wins, Judge? If I have a right to remain silent and I invoke it, how can you tell me I have to break it? If they're required to Mirandize me and they don't before I answer any questions, how can you say that they're right when they don't do it? And I'm not required to remind them of it. They're required to fucking know it. So again, it just rolls on and on and on.
Yeah, there's another one too about them having to take us to the magistrate.
Right.
Because I was never brought to the magistrate in the case of...
If they arrest you without a warrant, the first place they have to deliver you to is a magistrate. They're not allowed to take you directly to jail, though it is their practice to do so.
Yes. And the way this guy got the warrant was running my information. Well, you had a warrant, but I wasn't summoned to no warrant, nor was I given any notice of any warrant. So.
Well, and he wouldn't have had any right to your information because the stop itself was illegal. The fact that he doesn't know the law is not your problem, though the courts say he doesn't have to know the law. It just has to be a reasonable mistake. Well, the problem is it's not a reasonable mistake if we can show that he's never bothered to read the fucking statute. He can't make a mistake about something he never fucking knew.
Yeah. Because then if he made a mistake and he knew about it, then it was knowing and willful.
Yeah. An honest mistake by a reasonable officer is one thing. A complete omission because of ignorance, that's a whole nother animal.
So basically, you're saying then that even though they're out there enforcing the transportation code, they don't have the authority to be enforcing. They're still going
to. Most city cops do not.
Exactly.
Most county cops do not.
Exactly.
Oh, but here's another thing I read, Eddie. They say that the memorandum of understanding is not required.
Well, that's not what the administrative code says.
Yeah, they're saying it's not required for the...
Who's saying? Who is saying?
Well, I did a search on it, and they're saying, and of course, you know how the searches are always wrong about things because it's AI crap. But there I was reading that, oh, that's not a requirement. It's just a suggestion. I'm like, no, that can't be right.
No, it's not a suggestion. It's required by the Texas Administrative Code.
Do you happen to know which section of the code I can refer to?
4.13C.
Which one?
4.13C of Title 37.
Oh, thank you.
Well, still, it's going back and discrediting the attorneys and all this.
Okay. If you want to discredit the officer on the transportation code, the easiest way to do it is to actually look at the transportation code itself. Every single chapter that deals with enforcement, licensing, or any paperwork other than registration and titling is lorded over by the Department of Public Safety. This, once again, is exactly what the chapter in the Transportation Code says, and it's what the chapter, the Rule 1.1 and 1.2 in the Administrative Code says, is that here are the programs, here is who is responsible for those programs, and it's always the Texas Department of Public Safety. Then when you go to the individual chapters in the Transportation Code, it always says an officer. Well, when you look up the definition of officer in those chapters, it says an officer of the department. When you look up the department, it says the department is the Texas Department of Transportation or the Texas Department of Public Safety. Okay?
Yeah, that's exactly what I just read.
So, the only officer that by default has any authority to enforce any provision of the Transportation Code where that officer is defined as an officer of the department and the department is the Department of Public Safety is a DPS trooper. Right. By default. Therefore, the only way anyone else can do it is if there is a specific statute that authorizes it or there is a mechanization by which they can become authorized. And that is what Rule 4.13 and the Memorandum of Understanding and the training and certification requirements that the Memorandum of Understanding is meant to convey all comes together to make an officer either eligible to enforce or not eligible to enforce. And even then, the local officers are limited to enforcement that coincides with the requirements of Chapter 644 of the Transportation Code. And if you look at Chapter 644 of the Transportation Code, it is 100% commercial motor vehicles and ports of entry.
Yep.
And way stations. Sorry. And way stations.
Well, that's it in a nutshell. It's just knowing it and arguing it.
Now, see, once again, completely from memory. No notes, no nothing. Just there it is.
Well, good. I'm going to write it down.
So,
And then all the processes that these attorneys do, that's the ones that's really I want to get after too.
well,
And
the
especially
judges and the
Brady.
prosecutors, their processes violate the law.
Yeah.
That part we've got them on dead to rights.
Well,
And when they're acting in violation of the law, they're not acting in their official capacity. It cannot be a judicial function if it was a violation of law. Because it cannot be reasonably stated that a judge may act in violation of the law to act as a judge. That's a self-contradicting statement.
You find a lot of those. All right.
Hey, Eddie,
Yes?
I asked you a question about an Arizona issue that I had recently.
You can ask me. I don't know if I can answer it, but you can try.
All right, so I'm out here in Arizona. I was staying at a hotel, and the hotels out here, they have flock cameras all around the buildings.
Yep.
I noticed. So I went to leave one day, and all of a sudden there's these police officers just swarming the parking lot like sharks. It was kind of unreal, actually. I didn't think anything of it because I wasn't doing anything wrong. I go to leave, I pull out of the parking lot. Instantly, they're all up on me. Come up to my vehicle. The first question is, do you have a gun on you? Which I did. So I just told them, yes, a legal gun. They ripped me out of the car, me and my passenger, stand me on the street, take my ID, everything out of my pocket, run it just on their own. Then they're like, can we search the vehicle? I said, no. They get a drug dog, come out there, claims the dog hits. There's nothing in my vehicle. They search my vehicle, saying they had a trace. They find nothing. I have a female passenger with me. After the stop was over, the police officer who lets me leave, the male officer goes and frisks my female, searches her. Long story short, they let us go for a note, or I got a expired tags and insurance ticket. I was just curious your thoughts on that, or how you might want to proceed.
Well, first off, what grounds did they have to stop you?
Expired tags.
Were you still in the parking lot, or did you ever enter the public road?
I entered the public road when they pulled me over, but they have been obviously found my vehicle with come to find out, I was in the office paying the next week, and then they did this to another person. I don't know if it's the out-of-state plates thing or what it is.
You were from out of state?
I'm in Arizona. My plates are Texas.
Okay. So how did they know it was expired?
They had to have been. They have those flock cameras. I'm assuming that's
Doesn't
why.
matter if they have flock cameras. They don't enforce Texas law. They don't know what Texas law does or doesn't require you to do to register a car. They don't know if the shit's in the mail. They don't know if you've got X number of days from the date of expiration to get it redone. So unless it's like years out of date, what was their basis for stopping you?
They told me that the hotel I was leaving has a lot of drug activity, so they're stopping vehicles that pull out of there.
No, that's an absolutely illegal stop.
Correct.
They don't get to stop everybody just because there's some activity that may occasionally take place at some location.
So
Then again, that's Arizona for you. The cops in Arizona are fucking scumbags.
They're worse than Texas. I always wondered, but here they're worse, I think. 100%. So they basically, actually, they've been swarming the parking lot for days. So they must have just saw I had the expired tag. And so,
No, what they did was find a place to generate a lot of revenue.
Right.
I guarantee you that was not the only hotel, motel, or whatever the fuck it is in the area that had that issue.
Right. And it's the municipal police doing it.
Yeah. They're in there generating revenue. They're trying to catch as many cars as they can and people in them.
Yeah. So with they used my expired tags as the reason for the stop, though.
But again, your tags weren't from their state.
Okay.
And unless they're boned up on Texas law as to when you have to do something by and what the schedule is, that doesn't give them grounds to stop you.
Okay. Well, it was apparent they were on a mission because there was cops at every exit. When I left, they thought I don't know what they were looking for, but then, like I said, they after the stop, right when they pulled me out of the car,
they were looking for revenue. They were looking for people to hem up to generate revenue.
Great, yeah.
They issued you a ticket, right?
Yeah.
And they want you to pay it to them, right?
Correct.
They want you to pay them for expired registration for a state that you don't live in.
That's an excellent point. You're right. I was just curious about the way they handled it. Right when they pull up to my car, they're instantly asking about the gun, ripping me out of the car, taking my ID out of my pocket, running it, searching my passenger after I gave them no consent.
Yeah,
There's nothing
they had absolutely no legal right to do in any way, shape, or form.
Yeah. All right. I'm just wondering if it's worth pursuing.
Well, again, did they tell you that that's why they were getting you out of the car?
They didn't tell me anything. They refused to tell me why they even stopped me.
So did they find out about the registration before they pulled you out of the car or after they ran you?
They already knew. It was evident that they knew.
Well, if they didn't tell you anything, how do you know they already knew?
Excellent point.
So you're making assumptions. You know what that is, right? When you make an ass out of you and me?
Yeah.
Stop doing that.
Excellent. Yeah, that's an excellent point. That's what I'm doing wrong. Okay. All right.
True or false, you don't actually know what they used as the basis to come pull you over, do you?
I do not.
You just assumed it because you knew your registration was out, right?
Yes.
And then they wrote you a ticket for that after the fact, right?
Correct.
But they didn't do that until after they had your ID, right?
Yes.
And they had copied down the VIN number on your car, right?
Yes.
So you don't know what they knew before they stopped you.
That's right. You're right. I was assuming. Generating revenue. You're exactly right. It's terrifying, when they pull you out of the car like that, your family's with you and just rip you out. It's crazy. My dog's with me, and
well, if you think they give a shit, they don't.
I know
that's the problem with policing in America. Do what you're told, not what you're supposed to.
Literally gives you PTSD. I mean, you can't even go anywhere. Just you do nothing wrong.
That's the one thing the cops don't understand, unlike the military. The military has to be dead certain they're being given an unlawful order before they can disobey it. Cops don't. Cops can simply say, no, I fully believe that to be wrong and I'm not doing it.
Pretty sad.
It is, but it's the way they like to operate. Until we actually do something to create real police reform in this country, that's the way it's going to stay. You want to know how we make American police nicer and more competent? We take away their ability to use guns and any other type of force that they can't prove is necessary. You want to see them become nice real fucking quick? Wait till they're out there barehanded having to pull the shit they're pulling now.
Never happen.
It wouldn't happen.
Nope.
Not a chance.
But that current nil well. More and more.
I don't know who's talking, but you're breaking up really bad. You might want to try that again from the top.
This is James. I said that would be great if that were to happen, but it never will. We're in a state of continual militarization of our police forces in this country, and I don't see that ever changing.
Well, it needs to change. The problem is we need a better way of thinking about how policing ought to work, and we damn sure ought to make it where they can't become police without 5 years of school. Just like you should absolutely have to have a college degree to be a cop, and that college degree must involve constitutional law and constitutional history. That should be mandatory for every cop in this country, period. No bachelor's degree, no fucking badge.
That alone,
most certainly not a fucking gun.
That's 99% of them they would disqualify at that point.
That plays into articles that I've read on it before. Mind you, I can't verify that they were true, so I'm speaking from that position. But that certain cops that have sued because they've been refused employment because they have too high of an IQ level. They are too.
No, there's actual court. There's an actual court case on that.
I believe that's what I'm speaking from. So it's intentional. It's part of that. I mean,
Yes, they want order followers. Okay, they don't want people that think critically and rationally. They want order followers. They want trigger happy, gung ho motherfuckers that will do what they're told for a fucking paycheck. They basically want their own mercenaries.
Yep.
And if you think that's not what policing's become in this country, then you ain't been paying attention. They want their own gang of hired mercenaries. And the first time you know you've got one is the guy wearing the tattoo sleeve up to his fucking armpit.
Hey now.
They either want to be Joe Blow badass or they want to operate like Joe Blow badass because they've already got the attitude.
Especially when they got that Punisher tattoo on them.
I got nothing against the tattoos, don't get me wrong. I'm just saying if you want to recognize a cop that's got that mentality, that'll be the cop that has it.
Or the one really blowed up on roids.
Yeah.
Well, they'll be also the ones that usually have tattoos out the ass.
That's true. Yeah, the only thing you can do is just diffuse them and just smack them upside the head with paperwork. And that's where you get the pencil fuck them.
I'm waiting for the day when they make it okay for cops to put the fucking MS-13 teardrops under their eyes for every civilian they've killed.
On another note, recording in courts where they won't let you bring your cell phone in or any kind of device. Has anybody had any luck or used any of these recording pens? It's a pen that's set up as an audio recorder.
The problem with almost anything like that is, one, it makes a god-awful racket when it's in your clothes because it rubs on your shirt. It won't stay put. It flops around. If you're using it for video, fucking forget it.
Yeah, it's just for audio. Would be.
Hey, check this out, though. I did use a spy pen when I had a case going over in Rockwall. It was about 2015.
Okay.
Something like that.
I also used one too.
Oh, so anyway, I took that. The stupid judge called us back in the chambers, and so I turned it on when we went back in the chambers, and so I got her recorded on that thing, and yeah, it was kind of sketchy because it was flopping around just a little bit, but it was in my suit, so I was trying to sit there where I'd face her real good. Well, this little judge, she was just going off. Well, I posted it on YouTube because I had a YouTube channel back then. Oh man, everybody got all kinds of. That thing got a lot of views. It was great.
And Eddie, on that point, if they've got a rules in the court against recording like that, and you do release something like that or use something like that, is there a way legally they can come back on you for that?
Yeah, contempt of court.
Contempt of court.
Yep.
Even though it's supposed to be a public trial or public hearing.
A public hearing is exactly that. The word public in that instance does not. The judge has the power to control his courtroom environment. Now, I don't agree with how they're allowed to do it, but the fact of the matter is that's the way it's viewed by the judges that have to make the rules right now. If it was me, there is not a courtroom in this country that would not be equipped with audio and video recording equipment 24/7. Every court would be open every fucking day of the week, 24 hours a day, 7 days a week. No ifs, no ands, no buts. Every person arrested must be taken to that court. They must be properly arraigned. They must be given their examining trial before anything else occurs. If you do anything else with them, your ass goes to fucking jail. I don't care if you're the cop, the judge, the prosecutor, doesn't matter. You don't follow those steps, you go to fucking jail. Your camera and audio equipment doesn't work, you go to fucking jail. That's the way we ought to set it up if we want a system that's protecting our rights.
Absolutely.
But the problem is, every branch of our government is under the control of the Bar Association. Every fucking one of them. So they write laws that protect themselves and fuck the rest of us. And that's why we can't get ahead. Because our entire government is monopolized by fucking attorneys. Every branch of government by one elitist group.
What was that case that where the boy he won where you could film public officials or in public and stuff? And I forget the name of the case now.
Well, there's lots of them.
Well, it was pretty popular. Where anyway,
yeah, here in Texas, it was the Batusai in Austin that won the case. There's also Glick versus Conniff. There's
one in Fort Worth. What I was getting at is, a public building that should be considered public. We should be able to.
You can record in a public building, but a courtroom is a different thing.
Why would it not be considered public too?
It is public, but again, it's different in the fact that there's a certain level of decorum. I'm not saying that they should be able to prevent us from recording, but they have to be able to keep order in that room for the entire reason of what that room is for.
To hide the criminal acts that they're trying to.
No, the simple fact that it's supposed to be a place of justice, and that things are supposed to move expeditiously and correctly, without a bunch of bullshit.
Without it being filmed that they're doing it incorrectly?
No. Again, in my opinion, every court should have to have audio-visual recording equipment.
Sure.
And all transcriptions have to match what's on the audio-video recording equipment.
Right.
Okay? And all of those audio and video recordings must be publicly accessible, as should be the transcripts of every fucking trial. Period. That's my opinion. But the attorneys are in charge of making all the rules that govern all of that shit, and that's why they're written to protect what they do the way they do it. Doesn't make it right, doesn't make me agree with it. It's just what is until we change it. And until we make it illegal for an attorney to hold public office in any branch of government, that's the way it's going to stay.
Well, I like the attacking of it, that the city attorney's acting as a state attorney. That's a great avenue.
Well, it's one of them. But the other problem we have is we have judicial functionaries operating in multiple branches of government, which is a violation of the separation of powers. See, there's another little problem for them that they keep forgetting about that I've told you guys about I don't know how many times now. Chapter 82 of the Government Code, the State Bar Act. The State Bar Act says very specifically that every officer, every person in the judicial branch of government, or every prosecuting attorney, every attorney is a de facto officer of the Judicial Department of Government. Okay? The statute says every attorney is a judicial officer. Okay. Article 2 of the Texas Constitution says, no person who serves in any department or office of one branch of government may exercise any power of authority belonging to any member of any other branch.
So guess what?
Which means every office, every attorney sitting in the legislature or in an executive office is in direct violation of Article 2. Period.
Have you made this argument?
I've got it written out. I haven't made it in a lawsuit, but it's one that needs to be made.
Yeah, it does need to be made.
So break it down. So an attorney cannot hold two offices if he's sitting.
An attorney cannot hold multiple offices under different departments of government.
So if he's working as a city attorney, he can't work
if he's working as an attorney, period, doesn't matter who the fuck it's for, he is a judicial officer as a bar member.
Okay.
If they're a member of the bar, which you can only be if you're an attorney, then you are a member of the Judicial Department of Government. Period. So says Chapter 82 of the Government Code.
So
as a member of the Judicial Department, you are forbidden by Article 2 to sit and operate in any other department of government or exercise any power belonging to any office or officer of any other department of government, which means the governor, the attorney general, the secretary of state, the comptroller, any legislator, any fucking where. They can't do it. This is exactly the same problem with municipal courts that allow the mayor to act as a fucking judge. The mayor is an executive office. He cannot sit in a judicial function. It's a violation of Article 2. Is it any wonder why the attorneys argue that the Texas Constitution needs to be written better? Because they can't understand it to argue it correctly. It's because they're fucking morons, and yet they're in charge. It's not hard to understand. It's not hard to follow at all what it says.
Well, that's in those elected type of positions, but what about city officials?
Where does Article 2 say elected?
Well, they have to read the thing first, which they never do.
Article 2 says no office, no person in any department of government. Doesn't say what level of government. It says if you're in this department of government, you cannot exercise any power of any office or person belonging to any other department of government.
And that's
any bar attorney can't be working for the city or any function.
No, again, not the same thing. They can work for the city as an attorney.
Right.
But what they cannot do is be a legislator. They cannot be an executive functionary. And they most certainly cannot be an attorney for the state.
It's Section 1 of Article 2, the powers of government, separation of powers of government among the three departments.
So the city attorney can't be prosecuting state cases. He's operating, just wearing two hats.
Because Article 5, Section 21 specifically gives the power to prosecute in the name of the state only to county and district attorneys. Doesn't give it to anyone else. As a delegated constitutional power, it cannot be really delegated to anyone. Not by the city or the county or district attorney, nor by the legislature, who is a completely different department. The legislature cannot redelegate a judicial power to a non-judicial functionary, or to a functionary that has no authority to act under that power, such as the city attorney.
I got it.
A city mayor.
Right. That's what I'm getting at. It's wearing the two hats. That's where where I wanted to pin it down.
It's not simply the two hats part, Scott. It's the fact that those two hats sit in different branches of government.
Exactly.
Okay, then stick with the branches of government hair splitting, not the hats hair splitting.
Okay, well, fine.
Arguing about the hats doesn't matter until you can show which department that hat belongs to. So it's better just to argue Department A and Department B. Can't be in both.
Right. Well, that's the crux of the argument for the city attorney acting out of scope.
But again, get them to acknowledge it, that they're wrong, and they're not going to do it.
Well, they don't necessarily have to acknowledge it. You can force them to accept it by suing them.
Right. And at that point, it's costing the taxpayers again. Well,
the fact of the matter is, what's going to happen is you're going to file a lawsuit against the city attorney for malicious prosecution and acting without lawful authority. They're going to try to hold up a state statute as their authority. And we're going to shoot the state statute down with multiple provisions of the Constitution. Okay, the state Constitution. That's going to show very clearly they cannot do what they're going to do. Then they're going to try to claim prosecutorial immunity. But they're also going to get slapped in the face with that when we say, look, you had no authority to act as an attorney for the state. You do not have an immunity of any kind as an attorney for the state. There is no immunity conveyed upon you by law as an attorney for the state or as a city attorney imitating an officer of the state. Therefore, you have no immunity. You're an asshole that acted outside of lawful authority, constitutional and statute, no matter what the fuck the statute says. Therefore, you have liability. And because the city let you get away with it, their liability is hitched to your trailer. Or your trailer is hitched to them. However you want to put it. But you're both fucked.
Perfect.
With these types of suits, does that require going to a federal court, or is that something you would handle in a state court?
Well, you'd start it in a state court unless you're going to claim federal rights violations, and then you'd handle it in both courts.
Okay.
The key thing is, if you're going to sue them in the state, then you use the state constitution and only the state constitution and the rights it protects. If you're going to sue them at the Fed, you use only the federal constitution and the rights protected at the federal level. That's how you separate it into two cakes. Okay? And you don't ever want any piece of that cake to cross over into the other. That's how you keep them from moving the state case to the Fed or getting the Fed case dumped back in the state. By never letting the two recipes mix.
Okay.
That's a good point. So you're just arguing the whole state constitution violations.
In the state courts, I would be. In the federal court, I'd be arguing all the rights violations created by the violations of state law.
Well, that's ultimately where it would go, though, is federal.
No.
Really?
Ultimate means you're starting in the state and going to the Fed. No. You make the state arguments based only on the rights protected by the state constitution. You never, ever mention the federal rights at all in the state case. Ever.
I get that. I'm just saying, when you get denied totally out of the state, then
you're not going to get denied out of the state unless you did something to get it kicked out of the state. You're filing two separate lawsuits because it's two separate jurisdictions.
Right.
Okay.
I think what he's trying to say is that if you don't find justice in the state courts whatsoever with it,
you may not find justice at the federal court either, but at least you're getting two bites at the same apple instead of just one.
Yeah. If there's no justice to be found, what's the point of doing it in the first place? I guess is the question.
Well, it's making it where the rest of the population sees what the system is doing, and thus the system is losing support by that population. See, the Texas Constitution gives the power to the people of Texas to get rid of every one of these fucking assholes in a day. We could wipe them all off the fucking map and take away all their power. But the moment we tried to do what the Constitution says we have every right to do, we're going to have a fucking civil war. Because they're going to use force to prevent us from exercising our rightful authority under Article 1, Section 2. Thus proving that they are an illegitimate government who will not comply with the state constitution. And thus losing all the support of the public because of it.
Well, now that's sedition.
No. Sedition is what happens at the federal level.
Oh, what's the state version of it?
Well, here we've got, we have a state level sedition charge. Okay.
Well, they're attempting to change the form. They alter the.
They're attempting to alter the constitutional form of government by
That's
unlawful means and use of force. That's exactly what they're doing. Armed
exactly.
insurrection. Because the moment they deny the people their right to alter or abolish every part of the government under Article 1, Section 2, they are engaged in an insurrection against the very people they're meant to serve.
That's
And
the charge.
because they're using armed personnel to do it, it's an armed insurrection.
Right. Well, there it is.
It looks like it's the same clause in Arkansas Constitution as well.
I'm sure.
Pretty much every state constitution has a clause like that. See, this is another argument I've always made. It is completely stupid to argue that any level of government, Congress or the state legislature, has the power to make law that says it's unlawful to resist the government when the government's doing something unlawful, while at the same time saying we have the Second Amendment to protect us from tyrannical government. That is the most oxymoronic motherfucking argument I have ever fucking heard. We have the Second Amendment so we can fight back against the tyrannical government. But it's against the law to fight back against the tyrannical government because they created laws that says you can't fight us. Even when we're wrong. So the argument there is these laws violate the Second Amendment. And the entire purpose of the Second Amendment even exists. Because there are times when the people have every right to armed resistance to a government that won't do the people's will. That is what you keep hollering the Second Amendment's about, right? It's what we all understand it to be about, right?
Absolutely.
Therefore, Judge, how can you say it's against the law to use it for the purpose for which it's intended? It's a completely stupid way to maintain power.
Well, it's working for them.
No, it's only working because the public's an uneducated bunch of fucking morons.
True that.
And lazy.
No,
Well,
not so much lazy as apathetic.
Apathetic, yeah.
Okay? And you know what my analysis of apathetic is?
What?
Apathetic is 89% pathetic. Count the letters, take out the A at the front, and that's the percentage of apathetic pathetic is.
Oh, God.
Fine use of percentages there.
Thank you.
You really studied that word for a while.
Don't take much studying. It's pathetic with an A in front. I mean, all you got to do is break it apart. A, pathetic individual.
Well, that's like slaughter, man. Take off the S and it's laughter.
And?
Let me ask you a question relevant to a case here. This is fun, but so I'm looking in. This is Arkansas statute. This is section 2751.2.1 limitations. I put it in. I posted it into the chat if you want to look at it or bring it on the screen. But a specific line in it, E. It says, in every charge of violation of this section, the complaint and the summons or notice to appear shall specify the speed at which the defendant is alleged to have driven and the prima facie speed applicable within the district or location. So key portion in this that I'm picking out is it says the complaint and the summons or notice to appear. When I called the county clerk about the case, I asked them if I could get a copy of the complaint, and they acted like they'd never heard of anyone asking for a complaint in the traffic citation in their court before. So I want to make sure I'm reading this correctly, and that by their own statute that they're supposed to actually issue a complaint along with their summons or notice to appear. Or if the citation could be considered as a complaint.
Well, again, what are the requisites of a complaint under state law? What does it say a complaint must contain? Does it give an exception for a citation to be used as the complaint in certain instances or for everything? Because here in Texas, they can only use it for the acceptance of a plea. They can't use it for anything else. If you plead not guilty, they have to create a complaint. They can't use the citation to prosecute.
Okay.
Okay? So again, you need to understand what the rules of procedure are and what they can and cannot do with any given piece of paperwork.
And that would be in the state code, or that would be in the rules of procedure for the...
Well, it's still a state code, but it would be in the rules of procedure most likely.
Okay.
It's in the rules of procedure 27.14D here in Texas. I don't know where it is in Arkansas or Colorado or Arizona or any California or any of those places.
Right.
But 27.14D is where it is here.
Oh, look, and one of the things I have been starting to see a lot of in these statutes is because of this uniform, I don't know, is it uniform commercial code that's the proper term for it? But they read uniform, a lot of it, from one state to the other. I was researching some guy's federal Supreme Court filing on right to travel, and he had posted about converting a right into a privilege, and it talked about that right as a privilege. And he was in South Carolina, and it gave the statute code. I found the exact same thing in the Arkansas code, worded almost exactly the same. So
yeah,
it seems like they're, in a lot of them, they are the same. And just by looking at what you put out for Texas code, I've been able to find a lot of the same stuff in Arkansas code. But that gives me a key where to look for what is the state law that a complaint must contain. I'll pick up.
That stupid thing, where are you? Okay, I don't know why, but that file won't open that you gave me.
The PDF file for speed limits?
Yep.
Let me see here if I can. I just click on it in the chat and it pops up in the.
I clicked on it in the chat too, and it wants me to download it, which I did, but it won't open once I've got it on my computer.
Okay. Let me see.
If it does opening it, it's opening it somewhere in limbo.
Let me see if I can pull up the Zoom window here again. Let me add it as can you read Word documents?
Yes.
Okay. Here's speed limit. Open.
It opened for me.
There's a. I don't know. Didn't want to load. Try to. Speed limit generally open.
It's basically the same thing like Texas.
Cannot be sent because it's currently in use. I got to close it right here. Close it. I don't know why it wants you to close a document just to be able to add it. But
all
right. So
Adobe Acrobat Reader had foobarred itself.
Did you get it to open then?
This basically reads exactly the same as a Texas statute does.
Okay.
Reasonable and prudent speed under the conditions and circumstances with regard to actual and potential hazards then existing. In other words, these are prima facie speed limits. Almost willing to bet you.
And it also says necessary to avoid colliding with a person or vehicle or any other conveyance on or entering the highway in compliance with legal requirements of all duties and duty of all persons to use due care. So
look down at subsection E. Subsection E. The defendant is alleged to have driven and the prima facie speed. Okay? Prima facie does not mean fixed. It's not set in stone. Prima facie speed limits is any speed that allows you to travel without running afoul of any of the things up here that you can run afoul of, such as a collision in the state of Texas. The only way to prove speeding in the state of Texas is if there's a collision. No collision, no way to prove it. But the other problem is there ain't no such offense to go with it.
No such offense to go with it.
There is no such offense in Texas law as speeding. Never has been. And even if there were, the only way to prove speeding is to prove that there was a collision and that the reason the collision occurred was because of failure to control the speed.
Right.
If the collision occurred for any other reason, there could never be an offense for speeding. Okay? Because the way to avoid liability for the collision is that the vehicle you collided with was not already lawfully upon or lawfully entering the highway at the time the collision took place. In other words, they cut across the lane in front of you. They entered the lane at a red light when you had a green light, etc., etc., etc. They had to lawfully enter the highway, and then you hit them in order for there to be a collision that would have made you the subject of a speeding allegation.
So would they consider just roads and cities highways, or would the highway be limited to like
545.352 gives you every description of roadway in Texas and what the default speed for that type of roadway is.
So this has that in this statute right here. And so I'm on US Highway 62, which isn't even addressed in this statute as that type of highway.
Well, no, it says, if it says highway, but the main thing is having a wreck. You have to have a wreck with somebody getting on the highway or messing around on the highway, on or off, in order for this statute to apply. That's what he's getting at.
I get
Texas statute does.
Yeah.
So what is the Texas statute that says that you have to have the collision for it to be?
It
545.351 subsection B.
545.341
351
351
subsection B.
Subsection B. Okay, I'm going to look and see if I can find that in Arkansas code.
Well, this is the Arkansas code I'm looking at.
Well, it is, but it doesn't say that in this part of the code.
It says it at the very top in section A.
Section A.
Yeah, well, you got 1 and 2, and number 2 is where that specific language is.
Okay.
In every event, speed shall be so controlled as may be necessary to avoid colliding with any person, vehicle, or other conveyance on or entering the highway in compliance with legal requirements and the duty of all persons to use due care.
Right.
It says it's almost exactly the same thing Texas says.
That's why I've said it first thing is I hadn't even seen this before, and it's like, shit, this reads just like Texas does.
And that's what I'm saying is looking at South Carolina code and then looking at Arkansas code, it's about the same. And
that's because one of the things the Bar Association pushed for when it became a national bar association was standardization of statutory writing across the states.
Right.
Now, not every state's this way,
No,
but a majority of them are.
Yeah, your just codes are different.
it's just using a different number to identify
Yes,
language.
It's a different
correct.
section number, and it may be worded slightly different, but the essence of it is essentially the same.
Right. Well, what was the term that you used? Because they omit part of it and they're supposed to use one and two. It can't be just they're going off of one.
The conjunction and.
Well,
if it doesn't say or, it says and, then they have to comply with both sections on either side of the and.
I understand, but
And subsection B has an and in the middle of it.
This one doesn't for
I know this one doesn't, but Texas does.
I know.
Right. And so I'm trying to find how I can find that possibly if it does exist in the Arkansas statute.
Okay. First thing is speed greater than is reasonable and prudent under the conditions and having regard to the actual and potential hazards then existing. That's your caveat right there.
Yep.
Okay. The speed, if there is no collision, can't be said to be unreasonable.
Right.
Because you controlled your speed and thus avoided any collision. Okay? If you did it in a way where you didn't injure any other person or vehicle or lose control or damage property or any other part of the road or anything else, there is no argument that is objective that your speed was not reasonable and prudent. Mm-hmm. Any argument they make is 100% subjective, which is not what the statute requires. The statute, the way it reads, is objectively reasonable and prudent. There was no collision. There was no damage to person or property. There was no injury to persons. Therefore, there is no objective argument that the speed was not reasonable nor prudent.
No, I was just thinking of that. What is it? The Latin word. There's like two Latin words, and they have to use both of them, and they were trying to omit one. And there was just some word you used. I can't remember what it was. It's a long time ago.
You'd have to refresh my memory.
I'm trying to refresh mine. Shit.
Because I know lots of Latin words, so I don't know the two in particular you want to talk about, unless you're thinking adjustum generis.
Say it again.
Adjustum generis, but that goes with includes and including, not and.
That's not what I'm thinking of. Anyway, don't matter. But basically, they had to use both sections and prove both sections, and they wasn't using both sections. They were always just going off the reasonable and prudent.
Well, here in Texas, they try to use A without B.
Right.
And they can't. A is a general declaration. B is a specific requirement.
Right.
Okay? So A is worthless without B.
Yeah. Because
the
B
same
points
thing
out
here.
The liability.
A1 is worthless without A2.
Right. But then but since they don't have the and, could they just?
It doesn't need an and. Tell me what this is if it is the only thing that's here. What is this entire sentence if 2 is not used? What does that make this entire number 1?
I know, but that's under section
No,
A.
stop. Answer my question.
They can't use either one. If there was.
Scott, that's not what I'm asking. There is a specific thing that you would call everything that's in number 1 here. What is it?
Subjective.
Correct. The law cannot be subjective.
That's why.
Because what does subjective mean? Whatever the fuck you want it to mean, whenever you want it to mean it.
I get that part. And number 2 has a specific liability.
Correct. That right there is what creates the and, whether it's written or not. Without the and, number 2 included, 1 is 100% subjective. Every single word in it, completely subjective.
I've got that part. So
Okay,
that's all
well,
section
that's the
A.
argument, Scott. That's my point.
But what about section B? Would they can't move to section B?
All
They'll
B
be
tells
in A.
you is what the maximum speeds are for a motor vehicle on this piece of road.
That's right. And that's what they would attempt to bypass A and just use B.
Again, they're limited by reasonable and prudent.
Okay.
There's nothing down here that says the maximal speed limit for a motor vehicle. What's the definition of motor vehicle, by the way?
It's somebody that's being paid to operate a commercial
No.
vehicle.
Where does the statute define motor vehicle?
I don't have that committed to memory.
Well, there you go. Find it, then we'll talk. Same thing with the word operated. Same
Right.
thing with controlled access highway. Those are things you need to know the actual legal definition of before you start arguing anything.
The legal terms of art. Yeah.
And then right here, the maximum speed for a commercial motor vehicle, which will be compound in conjunction with a motor vehicle.
Operated.
There will also be a separate definition, almost guaranteed, for the word vehicle.
And
So
operated.
you will have 3 definitions to look up: vehicle, motor vehicle, commercial motor vehicle. And I guarantee you will find 3 definitions of exactly those things.
I have looked that up, and I have seen them. I'll have to find where that is.
Well, remember this. They are compound definitions. Each one of them contains at least one other term that is itself defined by the same statutes. Thus, it's a compound definition. In other words, you cannot read commercial motor vehicle without including the same definition that's found in motor vehicle, and then also including the same definition that's found in vehicle as one big fucking definition of commercial motor vehicle. That's what a compound definition is.
Article 27, Transportation Code. Let me open that real quick. On provisions, motor vehicles. 7.
Now notice also where it says, consistent with the requirements of subsection A of this section. Again, reasonable and prudent. How do you prove you're acting reasonable and prudent? There was no collision. There was no damage to property. There was no injury to persons. Therefore, no injury inherently means reasonable and prudent.
Got it.
Otherwise, it's completely subjective as to what's reasonable and prudent. Capiche?
Capiche.
Yeah.
Now, as used in this section, commercial motor vehicle means any motor vehicle used in commerce to transport passengers or property. So right there it tells you straight up, commercial motor vehicle means any vehicle used in commerce, any motor vehicle used in commerce. But go look up motor vehicle.
Motor vehicle
tell you that it's a vehicle.
It means every vehicle which is self-propelled and every vehicle which is propelled by electric power obtained from overhead trolley wires but not operated upon rails.
Right. And what's the definition of vehicle?
Let's see here. Vehicle.
Now, I want y'all to pay very close attention to H. I want everyone to read this section very, very carefully. because it tells you something. The question is do you understand what it's telling you?
It's just simply saying that any vehicle that's specifically used in commerce.
It's just defined commercial motor vehicle.
That is not what it says.
It just defined what a commercial motor vehicle is.
What does it define a commercial motor vehicle as?
Any motor vehicle used in commerce to transport passengers.
Correct. Therefore, motor vehicle is any vehicle used in commerce to transport passengers or property.
Right.
Okay?
For hire.
Under this section, a commercial motor vehicle is a motor vehicle that's used for commerce.
I'm not finding vehicle, just a term vehicle anywhere in the code.
I guarantee you it's in there somewhere.
Okay. Just vehicle alone.
Yep. Just do a search for vehicle means. Okay?
Okay. Doing it right now. Vehicle.
So, up here where it's talking about motor vehicle, anywhere it says motor vehicle, you come down here to H and it tells you that a commercial motor vehicle means a motor vehicle that is used in commerce to transport passengers or property. Hence, a motor vehicle is a vehicle that's being used in commerce to transport passengers or property. So take the definition of motor vehicle, a device that is self-propelled. So this means a device that is self-propelled used in commerce to transport passengers or property.
That covers commercial motor vehicle, but how does that cover motor vehicle?
Because it can't be a commercial motor vehicle unless it is first a motor vehicle being used in this manner.
Right. I understand that about commercial motor vehicle, but how is just motor vehicle without commercial before it? How does that fall into that aspect?
Because if you look, you will find out that the entire purpose of this set of statutes is to regulate the act of transportation.
Right, and that's the code that you sent me, the state code where it says
correct.
Transportation means.
Exactly.
Yeah.
Okay, and transport is synonymous with transportation. I guarantee you, if you look, you will find that this code, either in the administrative code for Arkansas or somewhere within this code itself, it specifically attaches every one of these terms and statutes to Title 49 of the United States Code or Title 49 of the CFR.
Vehicle, Arkansas State Code. Vehicle means a device in, upon, or by which any person or property is or may be transported or drawn upon a public highway, excepting devices moved by human power or used exclusively upon stationary rails or tracks.
Again, transported. Transport and transportation are synonymous. If you find where Title 49 governs, which I guarantee you'll find it if you look in one of those places, if you go to the home page of the Arkansas statutes and you do a search across all codes, including the state administrative code, which you may have to go to separately and search there for the term, but if you do a search for Title 49, you will find the section that ties all of these statutes back to federal law. And the federal law it will tie it to tells you that transportation and transport in federal law means the same thing.
Yeah, and the research that I've done on this so far for Title 49 suggests that Arkansas incorporated certain portions of Title 49.
Which is exactly what Texas did. And part of those portions contains the definition of these terms because that what you're reading also says They adopted all definitions and interpretations along with the statutory sections. Right?
Okay. I do not recall seeing that, but I will look for that.
I guarantee you it says that. It wouldn't have done them any good to say it without it.
And in the Texas code, can you rattle off where you find that in the Texas code?
Texas Administrative Code. The specific section, it's 4 something. It's under Title 37, Rule 4, one of the rules in Chapter 4. 4.1, I think.
For what?
4.1, I think.
4.1. Okay.
But hang on just a second and I can tell you for sure. Let's see. Go to my updated version of the seminar book.
Yeah, and your seminar book, can that just be purchased separately, or do you have to buy the whole seminar? Or?
Well, you buy the whole seminar, but this is a new version that I'm doing.
Okay.
Let's see. Uh, 2201. No, wrong one. $13. Title 49. Let's see. Okay. All right. 49 CFR 171.8. That's the sections they adopted. And 49 USC 113, which is what controls what's in 49 CFR. And let's see, for Texas. All right, yeah, 4.11.
The Title 37, 4.11?
Yeah, Texas Administrative Code Rule 4.11, which is under Title 37.
Okay. A lot of what I've been doing is even if I can't find it in Arkansas code, if I take some of the wording out of the Texas code and then research just that wording.
There's the link to 411 in this. Let's see.
Okay.
Looks like they've changed the address somewhat too. So
site is moved. Go to the site.
Yeah, go to the new site. See if it gives you.
It's just got a search back.
View Texas Administrative Code, Title 37. And let's see. Texas Department of Public Safety under Part 1, Chapter 4. Okay. 4.12.
Use the search TAC?
No, hang on. Well, you can, but you don't have to.
So what route did you take?
I followed the link to the website.
Right, I've got that. Now I'm at rules, meetings, and portal navigation. Search TAC, search Texas Register, search open meetings, view TAC.
View TAC. That's the Texas Administrative Code.
Okay, got it.
Then you go to Title 37, Part 1, Chapter 4, Subchapter B, Rule 4.11.
Chapter 37, Part 4. Part 4 is Texas Military Department.
No. Part 1,
Part
Chapter
1.
4.
Got it. Part 1, Chapter 4.
Subchapter B,
Chapter
Rule
B.
4.11.
4.11, general applicability and definition.
Okay. And as you can see right there, the Director of the Texas Department of Public Safety incorporates by reference the Federal Motor Carrier Safety Regulations, Title 49, Code of Federal Regulations. Then it gives you the various parts, including all interpretations thereto. Now, the thing is, even if any of these numbered parts do not relate specifically to the definition section of federal law, since they incorporated the federal law, they must incorporate the federal definitions to go with it. So even if the definition section is not one of the numbered sections, it still applies. You follow?
Okay.
They cannot incorporate the federal law, but ignore the federal definitions that govern that law. That'd be like saying, I've got a deck of cards, but I'll call each card whatever suit I want to, whenever I need to.
Oh.
But in any case, that's what you're looking for.
All right. One other question here, real fast, if you're open to it. I got the Word document that I loaded. It says redacted version on it.
Word document from what?
In the chat, it's a Word document called redacted version.
The one you uploaded.
The one I uploaded on the chat.
Okay.
Yeah.
What is it?
So that is a discovery that I'm working on for the officer. I know you got to look at the rest of the case, like you said, but just the things that I'm asking for in here. All records, regardless of storage measure. I used yours as a basic template, but then I added some things, like I changed the Texas codes to Arkansas codes that matched it, where I could find those. And then I'm asking for all the radar information, all the patrol car, the tire inflation, the tire sizes, the speedometer certification records, the officer's oath of office, the officer's bond. What is it? His surety bond.
You don't need his oath of office or his bond. But again, what you do need is his training records, his personnel file dealing with any complaints or investigations involving the officer, any Brady material involving the officer, anything like that.
Okay. And then all the information on the radar gun, the type, the
including maintenance records. Don't forget to ask for the maintenance records.
Okay. Yeah. Okay. And then asking them about the traffic surveying, the traffic surveys within the meaning of the transportation code conducted within the past 5 years. Am I asking the wrong person for that?
What traffic surveys for what?
So as a requirement for a change in speed limits or a prima facie speed limit, it requires a engineering and traffic survey within the meaning of, and it's Arkansas Transportation Code 2751-201, conducted within the past 5 years.
Okay, again, if the statute very clearly says that regardless of the speed, it has to be not reasonable and prudent, no matter what it's posted as. Okay?
Yep.
And reasonable and prudent can only be objectively proven by injury to person's property via a collision with something or someone. What difference does it make whether or not there was a study done before the speed limit was changed?
Okay. I was just throwing the kitchen sink at it, everything in there.
Well, you can do that, but it kind of muddies the water on what you're arguing. You got to remember one thing about wading around in the pond, okay?
Yep.
You're going to stir up the bottom when you do. The more you stir it up, the harder it's going to be to see your feet and what you're actually after in the water, right?
Correct.
Okay. So why do that when it's not necessary?
Well, I'm doing my purpose specifically behind this, and this plays into, there's a website called freedomtaker.com, and it's not a bunch of sob sit bullshit. It's stuff that regular people are doing that works. And one of the things that this guy that's beat all these traffic tickets does is he puts in discovery for everything but the kitchen sink, everything and the kitchen sink. And a lot of times he says they just dismiss the ticket because they don't want to mess with all the work that it's going to cost them to do it, just to get to the point of doing all the discovery that's required for it.
Well, again, he can ask for what he wants. It doesn't mean they're obligated to give it to him. It has to be something that's relevant to the case or someone associated with the case, first of all. Otherwise, they can just say this ain't relevant and tell the court we don't want to give this to them and we're not going to. And the court will go, okay. So, again, this person tells you they've beat all these tickets. Did they give you a handful of these tickets and show you that they were dismissed? Did they have a court order saying they were dismissed? Signed by a judge saying they were dismissed?
I have not seen any of that.
Okay,
no.
Here's the thing. This is exactly my point about listening to people that do this shit.
Yep.
Okay? I can show you the cases that I've done of mine. What I can't show you is the people I've helped who haven't given me information back about their case. Okay? So the ones that I still have that I can find after moving and all this shit again, I can show you the records of what went on and how it was done, the transcripts and all this other kind of shit. But all these people that are telling you they've done this and this and this and this and this, but they're not posting anything that shows you they've done it, that's problematic.
Understood. And that's why a lot of this, and I understand your feelings about all the sob sit bullshit, and I've read it all. I've looked at it for years, wishing and hoping that it was fucking true, but I haven't found a single bit of evidence that any of it fucking works.
And you won't.
And I've seen a ton of evidence of people getting the shit beat out of them and locked up and thrown in jail, and even the big gurus of it, like David, David Straight? He was out of Texas, that part of that Republic of Texas group and all that shit. His wife got locked up. He got locked up numerous times. And they talk about all this shit and sell all these programs and stuff. And then, but you never see any information from anybody actually winning anything with it, actually beating it. No court cases, none of that.
Yeah, so well, I've had lots of people call into the radio show and say they've beat their cases. And that I helped them do it. They did what I told them to do, and they won. Now they've called in. Some people have emailed me stuff that shows that they got it dismissed or whatever. But most of them never tell me whether they win or lose. They just go do it. So sometimes they'll call in the radio show and say, "Yeah, I wound up winning that," or "I wound up missing court," or "didn't do this or that, and that was my fault." Blah blah blah. But the fact of the matter is, I don't tell you anything that you can't go to the law and read for yourself.
No, absolutely. And that's why I'm here with you, is because yours rings true and there's evidence behind what you're showing. It's not about...
I'm not saying they'll do what they're supposed to do. I'm not saying they'll obey the law. No. I'm simply saying this is what the law says and this is what you need to use to fight. It's your best tool and your best chance.
Right. And it's the only thing where you show up and you actually can hold some form of legitimacy because you're actually using their codes and their rules.
Yeah. You're beating them up with their own book. And that's exactly what we got to do.
Yeah.
All right, guys, we've been on here for an hour more than we were supposed to be.
Thank you, Eddie.
I want you guys to have a great weekend. Thanks for being here. If you have not renewed your subscription, tonight's the only free class. So if you want to be in here for any more, please get your renewal in. All right. In the meantime, y'all have a great one, and I will see y'all next Thursday, I hope. Yes?
Will you look at your email real quick? I resent the one that I told you that I sent you about hiring you to do some work for me on the side. Will you see that you got it tonight from me? It will be magistus@aol.com.
It hadn't come in yet. It hadn't come in yet, I just refreshed the email.
I sent it at the beginning of this session tonight. So for some reason it's getting bounced or blocked or something. Although you did get the last email that I sent with my recording in from the officer and all of that. So it's weird that this one's not going through.
Okay. Well, I'll look when it comes in.
So let me verify just real quick. Or you just tell me, what is the email address I should be sending this to?
taooflaw@gmail.com.
Okay, that's where I sent it. So.
Okay.
All right. Thanks, Eddie.
All right.
Bye.
Have a good night, guys.